One matter was filed yesterday, my lord. I pray it may come up on Monday, my lord.
New matter.
My lord, same prayer I have got eviction matter on Monday, my lord, filed yesterday.
Lordship, we have filed an additional affidavit on 29th, Lordship. Kindly this may be called for.
May it please your lordship. My lord, I humbly pray for your lordship permission to move to repetitions today, my lord, because of the urgency involved, my lord.
At the last item. If it's possible.
Yes.
I don't know. What is the urgency?
My lord, what happened, the petitioner is executing two works under the Public Works Department. Now, during the currency of the earlier tender, the executive engineer issued a fresh tender, my lord, for a balance show without cancelling my tender, my lord. And today is fixed for last date for opening of the fresh tender, my lord.
Today is the last date for?
Opening of the technical.
What do you mean last date for opening? There's no last date for opening. There's only one day for opening. Huh?
But they have stated in the press.
The last day of submission must be.
No, last date of opening technical bids, they have stated in the penalty.
Then after that, there'll be the financial bid also.
Very well.
Then
But my lord,
Monday.
because during the currency.
Mr. Counsel, we don't have time. It's not that the other day also I was sitting here till around 5. There's no time. There's a thing.
We'll take a chance, my lord.
You take a chance, but what about us also? Nothing will happen. You see, technical bid, even if you fall or whatever, financial bid has to be again considered.
But they don't mention anything about that.
There's a 2-bid system.
There is a 2-bid system.
Then
I am executing.
Monday.
Deep blue.
Please, your Lordship. Lordship, I'm praying for listing of an interlocutory application on Monday, Lordship.
Regarding what?
Lordship, it was actually petition was disclosed of yesterday,
Ah.
bank recovery matter, Lordship. Due to some inadvertence, after filing of the writ petition, Lordship, some subsequent event was hit.
After disposal of the writ petition.
Yes, yes, Lordship, after filing of the writ petition,
You said it was disposed of yesterday.
yes, it was disposed of yesterday, Lordship, but due to some inadvertence, one subsequent development, I forgot to bring to your Lordship's notice, Lordship. That should be. on
Then
record.
you have to file a review.
I also.
Is there a typographical error or something?
No, not that type.
Okay, anyway, Monday. Okay, that's
One day, Lordship, of list. May I please, Lordship? I beg to mention a item regarding the matter payment of vehicles, vehicles hire and
hiring of
hiring-
vehicles.
fuel charges.
Hmm.
The DC Deputy Commissioner of his Kamrup requisition
So what do you want? You want to list it?
last as per direction of the court to 25/1/2023, that court directed both parties to make a settlement regarding this, and there is some development, but the records needs to place before the honorable court. So hence the matter needs to be listed
When?
immediate after Bihu vacation.
After Bihu vacation.
Bihu vacation.
No problem. You fix a date with him.
Please, your lordship.
Hello, guys.
Lordship, would the concern of others, I like to mention item 19, your lordship. Doctor, item 19 of
Yes.
the daily list.
What?
This matter, your lordship.
No adjournment.
Senior counsel is not available.
Maybe. Just because it's not there for the asking. No.
Lordship, we have taken.
Maybe. If he's not there, you go in appeal. Next.
May please your lordship. I paid for listing him after withdrawal.
Withdrawal.
Monday.
Please, your lordship. Lordship, I like to mention item number 12.
12.
My senior is someone certainly has to go out of station for personal reason. Then the matter will adjourn for.
Okay, right. Adjournment prayer has been made on behalf of Mr. H. Sharma, learned counsel for the petitioner, on the ground that he has some personal difficulty. Accordingly, leave this matter after a week. No, this is the matter. Okay, after a week. Yes.
May please, my lord. My lord, we have instructions not to press with this content, my lord.
Okay, right. Mr.
A.
Chaudhary, learned counsel for the petitioner, submits that he has received instructions not to press the contempt petition. In view of the prayer made by Mr. A. Chaudhary, the contempt petition stands closed as not pressed.
Obliged, man.
No one appears for the petitioner on call, for the petitioners on call. The writ petitioners. No, the writ petition having been dismissed by judgment and order dated 24/2/2022, by holding that the petitioners cannot be termed in any manner other than encroachers. Comma. This court fails to see how fails to see how the impugned judgment and order judgment and order has been violated by the respondent. Stop. However, as no one appears for the petitioners, list the matter on Tuesday. Tuesday is what date? 4th.
That is last in my lord. This is the contempt petition, my lord. The operative question is at page 168, my lord. 168, my lord. Column 1, my lord. 168, my lord.
Yes. You have not been paid your money.
My lord.
Mr. Triple S Raman, learned counsel for the petitioner submits that the order dated 27/9/22 passed in WPC number 5992/21, 6896/21, 6315/21 and 6022/21 has not been complied with. Issue notice returnable in 4 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with AD within 3 days. List the matter of the phone.
All right.
Lordship, this is regarding non-payment of higher charges of vehicle.
So we'll issue notice for
My lord, in a similar case, your lordship was pleased to issue, let them verify, and if admitted, then let them.
I think, you see, because these are all old matters, right? Third, Miss
S. Kakoti, my lord.
S. Kakati, learned counsel for the petitioner who submits that the respondents have not paid the hiring charges of the vehicles amounting to rupees 53,10,496. Issue notice returnable in 3 weeks. Mr. N. Goswami accepts notice on behalf of all the respondents. List the matter on. List the matter on, give a date. You can 27.
This issue, your lordship, relating to a notice inviting tender, your
What is the notice inviting tender dated?
lordship, that date, your lordship is not there, but your lordship, I have annexed it into in 2022, your lordship.
Huh?
Page 21, your lordship.
Yes, so there's no date,
Date was not there, your lordship.
dated nil.
Lordship.
So when was this issued? Which year?
22, your lordship.
2020.
And work orders were issued, your lordship, on your lordship.
This is for what? This is for?
This is for your lordship, transportation of bulk petroleum products, your lordship. They say there's a transport truck, your lordship.
to be supplied by the tenders.
So the truck has to be supplied by the
Supplied.
tender.
Now, your lordship, this is
And the rates,
rates, your lordship. Rates, your lordship, with minus 10%, your lordship, of the schedule rate, your lordship. And your lordship will find, your lordship, our issue is relating to, your lordship, is the supply under reserve category of, your lordship, for the MSMEs, your lordship. For MSMEs, 25% of the supply of trucks, your lordship, is reserved. Your lordship will get it at page 31, your lordship.
yes,
Reservation criteria, your lordship. First one, your lordship, for STs and STs, your lordship. Then B1, your lordship, will get. In line with public procurement policy for micro and small enterprises, MSAB order 2012 and amendment order 2018, 25% of the total quantity shall be earmarked for the procurement from MSMEs. And out of the above 25% sub-target of 16%, that is 16% out of 20%, which is 4%, is earmarked for micro and small enterprises owned by scheduled caste or scheduled tribe entrepreneurs, and a sub-target of 3% is earmarked for micro and small enterprises owned by women.
so you're
I am not woman, we are general, your lordship. I am general.
you're
For-
general, so you do not come under the reservation.
Reservation, your lordship, but under MSMEs, your lordship will kindly come to page 32. The
No,
breakup.
I'm not getting what you want to say. Yeah, the supply of this tender notice
Tender
for
notice,
supply of this bulk petroleum,
there are 168 trucks.
168 trucks.
68 trucks.
Ah,
Now, out of that, your lordship, 25% is reserved for, your lordship, MSMEs.
25% for this MSCs.
MSMEs, your lordship.
Correct.
Now, out of that.
Out of this 25%, 16
60% is for, your lordship, this, your lordship.
For the males.
SCs and STs.
STs and SCs,
STs,
okay.
and 3% is for, your lordship, women,
3% for women.
women. Now, rest for general.
So 16% out of the 25%.
25%, it will come to 4%, your lordship, out of total. That they
Okay.
have defined, your lordship, in the clause.
So 16% out of the 25% is reserved for ST. So you want this, you want to
No,
be.
I don't want that. I come under general category, your lordship. Your lordship will kindly come to page 32. It will make it clear, your lordship. The table, quota wise allocation summary. Page 32, D.
D, yes,
Total 169, your lordship,
trucks.
trucks, your lordship.
Ah,
Then 25 SCs, STs 12,
yeah,
then MSC total 25, then it comes to 43.
ah,
Then, your lordship, women 3%, 5,
yeah,
it will have to go.
yeah.
Then MSC, SC, ST 4, 6, MSC general, your lordship, 32. I am concerned with this, your lordship.
Yes.
Now,
So-
your lordship, how is to be allocated this 32, your lordship? That is in page B2, page 31.
Yes,
The above provision will be subject to MSME quoting a price within price band L1 plus L1 lowest one plus 15%. That is L1 plus 15% and bringing down their price to L1 in a situation where L1 price is from someone other than MSEs. Now, in case of more than one such MSE, the supply shall be shared proportionately from MSE's party. Now, if it is more than one, your lordship, it should be supply
Shared.
should be given proportionately, your lordship.
proportionate to what? To the number of trucks?
Number of trucks, that is, your lordship, 32 trucks for the general, that will have to be proportionately.
So if there are two of them, then 16.
50-50, your lordship. That's how, your lordship, our high court has interpreted it, your lordship. That I have annexed, your lordship. Now, what they did, your lordship, they gave the first 5 tenderers the entire bulk, your lordship. If your
The first 5 tenderers, who are
No.
the first 5 tenderers? What do you
No.
mean first 5 tenderers?
lordship will kindly come to page 39. These are the, your lordship, MSC general category, your lordship. There are 21 tenderers, your lordship.
Correct,
Now, your lordship, the first 5, your lordship, 1, 2, 3, 4, and 5,
yeah,
they got the entire, your lordship, bulk of the,
they
your
got
lordship,
the entire 32.
32.
And
Now,
where are you?
I am at 18. This is the ranking, your lordship. All of them were L1, your lordship. All of them have quoted, your lordship. The
So
lowest,
according to you, all 21 of you should get.
lordship. That's what, your lordship, our High Court has interpreted, your lordship. Your lordship, I have annexed that, your lordship, there the, your lordship, may kindly come to page 57. This is the policy, your lordship, as per which this 25% quota is, your lordship, given. Now, your lordship will kindly come to page 59.
What 25% quota?
Page 57.
No, how do you say it's 25% quota?
Lordship, I will come. Here, your lordship, 25% quota, your lordship. Page 31, in line with public procurement policy for micro and small enterprises, order 2012 and amendment order 2018, 25%
okay.
of the total
What is the full form of MSCs? Micro and small
micro and
enterprise?
small enterprises, your lordship.
Yes.
Now, this is being done, your lordship, as per the policy, your lordship, that is 57 page.
Yes,
This is the 2012 policy.
yes,
Now, your lordship will kindly come to page 59.
yes.
In tender, participating micro and small enterprises quoting price within price band of L1 plus 15% shall also be allowed to supply a portion of requirement by bringing down their price to L1 price in situation where L1 price is from someone other than a micro small enterprise. And such micro and small enterprises shall be allowed to supply up to 20% of the total tendered value. Now, you will see this 20% in 2018, it was made 25%. Now, next, your lordship, in case of more than one such micro and small enterprise, the supply shall be shared proportionately to tendered quantity. Now, if your lordship comes to our High Court order, your lordship, at page 63, this is exactly the issue which arose, your lordship, for deciding, your lordship.
Yes,
Page 67, your lordship.
yes.
Same clauses, your lordship. Para 8, your lordship will kindly see.
Yeah.
Percentage of reservation of the 15% for SC, 7% for the ST reservation for MSME shall be as provided in the micro and small enterprises. Development Act so and so. 20%, at that relevant point of time, it was 20%. The total quantity shall be earmarked for procurement of MSCs with a sub-target of 20%, that is 4% out of 20% for SC and ST entrepreneurs. It was clarified that above reservation would be subject to MSC's quoting price so and so, and bringing the price to L1 where the L1 price is from someone other than MSCs. In case of more than one such MSCs, the supply shall be shared proportionately for MSCs. Then it is stated that the petitioner had applied under MSC general category for which 6 tank trucks were earmarked out of total 40. It may be mentioned that a total of 8 tank trucks were earmarked under MSME category, 6 for MSME general and 2 for MSME STSC. Be that as it may, following the price evaluation, the petitioner has placed at serial number 11 under L1 category. However, under the MSME general category, petitioner was placed under serial number 5. The tenderers placed above petitioner in that category were so and so, respondent number 3, NRL Energy Station, respondent number 4, MLC Enterprise and Rashid Ahmed Chaudhary in that order. However, when the allotment were made, found that Rio Enterprise, that is respondent number 3, was awarded 5 tank trucks, and respondent number 4, that is NRL Energy Station, was allotted 1 tank truck, both under MSME general category, totaling 6. Petitioner was placed at serial number 5 under MSME general category. Thus, the 6 tank trucks were earmarked for MSME general category got exhausted. Consequently, no tank truck could be allotted to the petitioner. Petitioner has asserted that the tank trucks were required to be allotted proportionately amongst tenderers, which was not done in the present case, thereby causing prejudice to the petitioner. He has submitted representation. Then this, your lordship. Then your lordship may kindly come to finding of the honorable court at page 70, para 16. There is no dispute that petitioner belonged to MSME general category for which 6 tank trucks were allotted. It is also not disputed that petitioner was placed under serial number 5 in the list of MSME general category. The allotment have been made by considering the number of vehicles offered by the tenderers vis-a-vis the number of vehicles owned by tenderers. Respondent number 3 had offered 5 vehicles, all of them being owned. Respondent number 4 offered 5 vehicles, out of which 4 were owned and 1 attached. As a paragraph 6.2 of the order dated 23/3/2012 of the Ministry of Micro, Small and Medium Enterprises, Government of India, In case of there is more than one such micro and small enterprises, the supply shall be shared proportionately. This is also indicated in clause B2 of part 7 of the tender documents relating to reservation, which says that in case of more than one such micro or small enterprises, supply shall be shared proportionately from MSC's party. Question for consideration in this context of the present case is the meaning of expression proportionality. Whether it will mean equal distribution of the total number of tank trunks available under the category, that is 6 amongst the eligible bidders, or giving the maximum allotment to the candidate at serial number 1, that is 5 number of tank trunks, and the remaining 1 to next candidate. Now, this was the issue, Your Lordship. In the course of hearing, Mr. Sharma, learned senior counsel representing respondent number 1 and 2, tried to explain the meaning of the word proportionality by referring to dictionary meaning. As per Oxford English Dictionary, proportion means a part, share, number of, considering comparative relation to a whole. The relationship of one thing to another in terms of quantity, size of number. Chamber Dictionary explains the expression proportion to mean the relation of one thing to another in magnitude. Appropriate relationship of part to each other as regards size, quantity, etc. to each other. Black's Law Dictionary defines the expression proportionate to mean justice or something else awarded the certain rate of comparative relation. Reverting back to tender condition, it was what is seen that as per eligibility to be eligible, a tender should have offered minimum 3 trunks, out of which he has to own 1. This is an eligibility and not allotment criteria. However, in the second part of the eligibility criteria, it is provided that maximum number of tank trunks can be offered to a tenderer is 5. On a careful reading of the eligibility criteria, it would reveal that a tenderer has to offer a minimum of 3 tank trunks, out of which he has to own 1. However, 1 being selected, a tenderer can be offered a maximum of 5 tank trunks. A conjoint reading of eligibility criteria together with paragraph 6.2 of Government of India order dated so and so, as well as clause B2 of part 7 of the tender documents, would make it clear that it does not mean that a successful tenderer would have to be offered 5
Yes,
tank trunks.
what to do?
My lord,
One more thing, Your Lordship. In the meantime, Your Lordship, work order has been issued, Your Lordship. Now, Your Lordship, I don't have any interim prayer as of now, Your Lordship, today. Therefore, Your Lordship, my prayer at this stage will be to issue a notice and let them come up with a affidavit.
That is it. But it appears that you have to see this judgment.
Yes, my lord, public procurement policy for the, my lord, medium and small industries, that has been, my lord, utilized. How that has been, my lord, applied, that for that, my lord, we have to come out with a.
Yes, yes. Keeping in view the judgment passed by this
Yes,
court.
true, my lord. So that instruction I'll have to have, I'll file a
Yes,
petition on that.
Okay, right. Mr. S. Bhattakur, learned counsel for the petitioner, submits that in terms of the NIT dated nil, which was published in the year 2022 for transportation of bulk petroleum products by tank truck, the petitioner took part in the tender process. He submits that in terms of the NIT and the order dated 4/12/2018, passed in WPC number 1604/2018, the 25% quota allocation reserved for the micro and small enterprises has to be distributed / allocated proportionately. Full stop. As all the 21 tenderers belonging to the MSCs
General.
bracket general had submitted their bids, which allowed them to be selected as tenderers, the allocation of the allocated quota of 32 trucks only to 6 of the tenderers,
Five.
5 of the tenderers out of the 21 tenderers was not proper. Issue notice returnable in 4 weeks. Mr. A. Borkotaki
Correspondent number 1, 2, and 3.
accept notice on behalf of respondents number 1, 2, and 3. Anybody else is there?
4 to your
Private
lordship,
respondents are there.
8.
Huh?
4 to 8, your lordship. 9 and 10, I will pray for striking off your lordship wrongly.
Okay. Okay. Petitioner takes steps for service of notice upon the respondents number 4 to 8 by registered post with AD within 3 days.
Close.
Full stop. On the prayer of Mr. S. Borthakur, learned counsel for the petitioner for striking out the respondents number 9 and 10. The said prayer is allowed. The respondents number 9 and 10 are accordingly struck off as parties from the case. List the matter after 4 weeks.
Lordship, may I pray for a date, your lordship? After 4 weeks, any date of your lordship convenience.
This is the hurry
Otherwise,
now.
it is very difficult to list nowadays, your lordship. That's the problem.
You give end of,
Lord,
May 8. List the matter on May 8 May 8/5.
deeply obliged, Lord.
His lordship.
Yes. What is your case?
I am challenging the order of confiscation. Sir, I am a
Confiscation dated?
confiscation order dated 15/12/2022. Lordship, I am a driver and owner of a pickup van.
Huh.
I am engaged in transportation of goods on contractual basis. And one gentleman hired my vehicle for bringing auger woods. And I accompanied him on good faith, and one sale deed was also executed to that effect. But on my way back, my vehicle was apprehended and I was arrested. Subsequently,
What were you carrying?
auger woods.
So that is not allowed.
That is, if it is, if it is purchased from authorized person, then it is legal. If it is forest good, then that is illegal.
So you purchased from where?
From Nagaland,
You purchased from Nagaland.
yes.
So you have got all the documents to show that you purchased from
One sale
Nagaland.
deed that is page number 40.
You have got the transit pass.
So only I am only the driver. I accompany I'm told that it's a legal thing and you accompany with me. But
You're not the owner.
I'm the owner and the driver.
You're the owner and driver.
Owner and driver. Subsequently, I was acquitted by the trial court. I was acquitted by trial court.
Acquitted from the offense of
Offense,
what?
alleged offense. That is
Alleged offense of transportation.
under forest regulation. That is illegal transportation of forest.
So you are not transporting anything.
I was transporting, but that was not illegal.
That is not illegal.
That was not illegal. Now,
Page, where is that order?
the impugn order is on page number, that is
28,
27.
It starts at 27.
Okay.
And the operative portion is on page number 29. Page number 29.
Is there any alternative remedy?
My lord, there is an appeal provision.
There's go to
49C, my lord, of
49C.
the forest regulation.
Yes, there is an
You appeal
alternative
right before
remedy.
the district judge.
But whatever, let's say. So there's a judgment passed by the Supreme Court in 1998, 8 HCC page number 1, that when there are under 3 circumstances under which if there is alternative remedy, then also I can approach the High Court.
There is there, but
That is-
it cannot be for all cases.
So yes, what has happened, that 3 points that enumerated in that particular judgment, that is that, and if I'm filing the petition for enforcement of any fundamental right, number 2 is any principle violation of principle of natural justice, and number 3 is the order, impugn order that is passed without jurisdiction. I am covered by the point number 1 and point number 3. That is what, because
How?
that is because this is my vehicle is the only source of livelihood. Because I am deprived from my source of
Okay,
livelihood. And
right.
3, what has happened? Page number 29, that impugn order that has been, that is the order passed under section 14(9). That is only the interim measure. And what has happened by this order,
Okay, what is your name?
that petitioner name,
Yes, your name, council's name.
B. Bora Rothschild.
Heard Mr. B. Bora, learned counsel for the petitioner, who submits that his vehicle was seized while transporting agarwood from Nagaland to Assam.
Lordship, can I, if you Lordship allow me, can I submit one sentence, Lordship? What has happened since I have been acquitted, now that alternate remedy that has been, because the entire proceeding is now wiped out, Lordship. The alternate remedy, that is appeal, that was only, because that was appeal provision, that was also, that is, because of interim measure only, because the entire proceeding is wiped out, Lordship.
What have I said? Huh? No, side. There's,
For Mr. D. Bora, Land Council, for the petitioner who submits that his vehicle was seized while transporting a worker from Nagaland to Assam.
oh, sir. He submits that that he is the owner of the vehicle, which was carrying the wood and which is covered by registration, which has registration number AS05C9456. The petitioner's counsel submit that as the petitioner has been acquitted from all the charges by the learned trial court. The confiscation of the petitioner's vehicle bearing registration number AS05C9456 should be set aside. Confiscation of the vehicle by the authorized officer come divisional forest officer, Jorhat division, Jorhat should be set up. Mr.
B. Chaudhary,
B. Chaudhary
for all the respondents.
appearing for the
Forest Department.
Forest Department submits that the petitioner can challenge the confiscation of his vehicle by approaching the
District Judge, my lord.
district judge under
49C,
regulation,
Section 49C.
under section 49C of the
Assam Forest Regulation 1891.
Assam Forest Regulation
1891.
1989,
1891.
1891.
My lord.
Next one. On hearing the counsel for the parties and on now, and in view of the fact that there is an alternative remedy available, this court is not inclined to entertain this writ petition any longer. The writ petition is accordingly dismissed with liberty being given to the petitioner to avail of the alternative remedy available.
Lordship, one sentence, Lordship, there is a limitation period of 1 month. Lordship, that may be considered at the time.
That limitation may be condoned, my lord. The appeal has.
If the petitioner avails of the alternative remedy available within a period of 2 weeks from today, the appellate authority should consider condoning the delay in filing the appeal.
Deeply obliged.
May please, Lordship. Lordship, before my senior friend starts, Lordship, I've just been
Just a
informed,
minute, huh?
my lord, before my senior friend starts, Lordship, I have just been informed that we are a necessary party in this matter. We have not been served a copy.
Who is-
and,
What is this issue? What is this a case about?
My lord, I don't have the brief actually, my lord. They haven't served us a
My lord,
copy.
the
nor
judge,
our names have been taken.
My lord, the petitioner.
I don't know if,
You don't want to be shifted to another district.
My lord,
That is your case.
my lord.
y-
Ours is this, my lord. We are belonging to non-BTR area,
You are
Non-BTR area.
belonging to non-BTR area.
non-BTR area.
Ah.
And
Non-BTR area.
yes,
Ah.
area. And these villages are sought to be transferred to the BTR area.
BTR means what?
BTR.
Bodoland
Land Territorial area.
Border,
Bodoland Territorial Region.
Bodo land
Territorial region.
territorial
Region.
region. Now,
And the.
now whether these are all policy decisions, administrative decisions, whether we can interfere.
My lord, your lordship will see the impugn notification. Just I am pointing out
Yeah.
one thing.
Yeah.
My lord, 114, my lord. page 114.
Yes,
My lord, this notification has been issued on 31st of December 22. I am
Yes.
reading out slowly, my lord.
yes,
The following 10 villages of Bhograpar Revenue Circular geographically contiguous and closer to Tamulpur district headquarter. My lord, just pause for a moment, my lord. Closer to Tamulpur district headquarter. My lord, it means these villages are contiguous and closer to the Tamulpur district headquarter. And we are, my lord, residing just near to Nolbari town. Nolbari town is the district headquarter of Nolbari district, and we are a resident of Nolbari district. We are residing just near to Nolbari town. That is the headquarter of Nolbari town, BTR, non-BTR area. And these villages have been shot to the Tamulpur district headquarter, and on the same day, my lord, that is on 31st December 22, this Tamulpur district headquarter district has been abolished. This
you see,
district
these are
has been
administrative
abolished.
decisions.
My lord, if I may submit, my lord, and the, if your lordship
It has been
fixes
abolished
this matter
and
in
my
the
lord,
next week,
it was,
I have
it was
Just a minute, you wait, not even in the picture right now, just wait.
Well.
Yes. You see, the question is this, these are policy decisions. Whether the court can interfere into these decisions, whether it should be in this district or that district,
no, that's, my lord.
what fundamental right of yours has been
No,
violated?
my lord, my lord, I am coming to it, my lord, I am coming to it. You will also will see what I am pointing out, Tamulpur district, if it is.
Look, have you
Tamulpur-
made any representation to the authorities?
Yes, my lord.
Where?
My lord, that is page 117.
117.
117.
You have made it to the deputy commissioner,
Deputy Commissioner. right?
deputy commissioner.
My lord.
Now, this shifting of your village from one
No, that's
district
right,
to
my
the
lord.
other
My
has been made by whom? Deputy
understand.
commissioner?
No, my lord.
Then?
That I understand, my lord.
No case.
So here for a moment, my
Then,
lord.
Mr. Counsel.
No, my lord, your lordship will kindly see.
No, you please listen first. It's a two-way traffic. You know, it's not that I hear only what you say. You have got to hear this side also. The issue is with regard to whether you should be in this district or that district. Correct? You say that you want to be in Nalbari district near Nalbari town. Very well. Nalbari town, you cannot shift the location of your village. But whether you have got to be in this district or that district, it is an administrative decision. It is made on the basis of a policy made by the government, public policy. Now, who has made the policy? Who has issued the order? Who has issued the impute order?
My lord, the Principal Secretary to the Government of Assam.
Principal Secretary to the Government of Assam, not the Deputy Commissioner. You write to the Principal Secretary. We'll let him take a decision. You give him a chance. Who is the Deputy Commissioner? Deputy Commissioner has not
It's not that, my
issued
lord,
that.
at that I may understand, my lord.
No case. In any event, it's the administrative decision, public policy. Now, what right of yours has been violated?
My lord, my lord, your lordship will, my lord, just I am pointing out one thing, my lord.
Oh, yes.
My lord, here, my lord has already seen close to Tamulpur district, my lord.
Close to, yes.
If it is Tamulpur district, my lord, all right, my lord. I am welcoming it. I am welcoming it.
Huh? Yeah?
I am welcoming it.
Huh.
If it is Tamulpur district, my lord, district headquarter, if our houses or the villages near to the district, as they have disclosed in their petition, my lord, the Tamulpur district headquarter, very well. But it is not so. Your lordship will kindly come to the next time, my lord.
Mr. Counsel, before coming to a writ court, isn't it your duty to first approach the authorities with your grievance? The competent authority, I'm not saying any authority. Say you have been terminated from service by a secretary to the government. Do you go to some other authority below that authority who terminates you? And in this case, the impugned order has been issued by a secretary to the government. You are going to the deputy commissioner. You go to the concerned authority first, then you come here.
My lord,
If you have the right to come here. We cannot
your
entertain this kind of writ
then
petition.
your
No.
lordship will make some observation, my lord. I will do.
Right. Heard, Mr.
M.H. Chaudhary.
MK Chaudhary.
M.H. Chaudhary.
MH Chaudhary. Your name is not here?
My lord, actually wrongly that has been given. M.K. Chaudhary, M.K. 2D, M.K. Chaudhary are there, my lord.
Huh? Let us see your Wakala Dama.
Avakal nama is not required, I'm senior, my lord. Senior.
Huh? Okay. Heard, Mr. M.H. Chaudhary, learned counsel for the petitioner, comma, who submits that the notification dated 31/12/2022 issued by the Principal Secretary to the Government of Assam, comma, General Administration Department, comma, by which 10 villages under the Gorghapur Revenue
My lord,
Circle,
Gograpar Revenue Circle.
comma, Nalbari District, which were outside the Bodoland territorial region have now been included in the Buxa district under the Bodoland territorial region, comma, should be set aside. He submits that the 10 villages which have been put under the Bodoland territorial region, bracket BTR, in short, very close, is closer to Nalbari town, which is within Nalbari district. And as such, the petitioners who are living in those 10 villages will lose various rights, comma, including political rights, if they are transferred from BTR to non-BTR area. Now, if they, from non-BTR area to BTR area. Next, the petitioners council submits that the petitioners have also submitted a representation against the transfer of the 10 villages from the non-BTR area to BTR area by representation dated 10/1/2023. So, however, no decision has been taken on the same till date. Mr. N. Goswami appears for the
It's for 2 and 4. Lord.
point number 2 and 4, and Mr. Huh? S.R. Raba appears for point number 6. Miss R. Devi appears for point number 1. Anybody else?
Lordship, I'm appearing for response number 3.
You are not a party, yeah?
My lord, I have been,
You are party.
in the case, they have been a party, but not in the cause title and, cause list, my lord.
Okay, Mr.
A. Fukan, your lordship. Standing Council, General Administration.
Mr. A. Fukan, Standing Council,
General Administration Department.
just administration, also appears for his point number
3, my lord.
3. So, sir. The next para, the respondents council, the councils for the respondents submit that the writ petition should be dismissed as the inclusion of the 10 villages from a non-BTR area to a BTR area is a policy and administrative decision. And as such, this court should not interfere in the said decision, particularly when there is nothing to show that any legal or fundamental right of the petitioners have been violated. Full stop. I have heard the learned counsels for the parties. On perusing the impugned
Page 1.
notification dated 31/12/22. It is seen that page
Page 114, madam.
114.
Right.
It is seen that the placing of the 10 villages mentioned in the said notification has been done for, well, the placing of the 10 villages in the notification within the administrative jurisdiction of Buxar district from Nalbari district.
Now, from Nalbari district to Buxar district.
Correct. Has been done for better administrative convenience and smooth flow of services to the public. Without going into the merits of the said notification dated 31/12/22. It is seen that the petitioner has not made any representation to the state government against the impugned notification dated 31/12/22. Instead, the petitioners have submitted a representation / memorandum dated 10/1/2023 to the Deputy Commissioner Nalbari. To include the 10 villages mentioned in the impugned notification within Nalbari district. In view of the fact that the petitioner has not availed of the alternative remedy available by first approaching the state government with regard to his grievance, this court is not inclined to entertain this writ petition any further. In any event, the petitioner should keep in mind the fact that it is not the domain of the court to embark upon an uncharted course in public policy to consider whether a particular public policy could be evolved. The prayer of the petitioner hearing appears to chart a course in respect of the domain of the executive perspective. In any event, keeping in view that the petitioner has not approached the state government with regard to his grievance prior to approaching this court, this writ petition, this court, this writ petition, this court is not inclined to exercise any discretion in this particular case. The writ petition is accordingly dismissed, with liberty being given to the petitioner to approach the respondent authorities to appoint the state government, which is grievance in the first instance.
Highly object.
You'll have to consider very carefully when you file these type of cases. You see, you want the later on, basically, you want the court to say that no, they should be in this district or that district. Whether we are going into administrative functions, you have to be very careful.
Here, my lord, the implement order is slightly different, my lord. They say, my lord, Tamulpur district, and on the same day, Tamulpur district have been abolished, and it has been taken to other district, which is a longer distance. That is the, otherwise, my lord, had it been a Tamulpur district, we would not have come, my lord. But in the later part, my lord, they said it was attached to Baksha, and that was 80 kilometers away from our house. That is our grievance. Some, my lord, instead of making that observation, if my lord will make some observation that petitioner.
You wanted me to make some observations, I made observations. According to, and if you want, I can put the Supreme Court judgments also with regard to that observation,
My lord,
from where it has originated.
only my lord, liberty to approach the appropriate authority by filing a report.
I told you in the very beginning, you should have done that. Now you wanted observations, I'm giving observations.
No, my lord, I have said so only, that I will do it. you-
Okay, we will see, we'll see. We'll see. We might cut it off. We'll see.
That I will do. Highly object.
Item 7. The petition has been filed, my lord, for the inaction of the respondent authorities is not demarcating the, my lord, plot of land of the petitioner, which he has already applied in February 2022. Thereafter again in September 2022.
You have applied for demarcation.
Yes, my lord.
Then isn't there a appeal provision?
Yes.
Then you go for, then you, since you have already availed of that remedy by going under that act, I think.
Not under the act, my lord, he was not aware of this, my lord, but he has applied.
She has
otherwise that is the
applied, but then
procedure.
you see, once if that act is there,
My lord.
then it can always be said that that act is, you have applied under that. You don't have to mention the provisions of the act, or that it is deemed that you have gone under the act because the act is there. So if that,
The act now prescribes the time limit only.
correct. Now, once the time limit of 30 days has now expired, then you file an appeal.
The appeal, my lord, that also, my lord, in that case, my lord, your lordship gives a liberty to file afresh, my lord, because he applied before the, my lord, the wrong authority.
Oh, she applied before wrong authority.
He was not aware of this particular notification.
Okay,
and all.
okay, okay.
Lordship may give the liberty that she will prefer it before the circular officer press, my lord, along with all the particulars as notified in this particular, my lord, act of 2021.
Okay, right. Third, Mr. D. Learned Counsel for the petitioner, who submits that the petitioner is the owner of land measuring 3 bighas, 1 katha, 10 lechas, covered by DAG number 117 and 118 of Pata number 40, bracket new, in village Mutupuri under Moza Hauli in Barpeta district, SM. The petitioner's counsel submits that the petitioner had approached the office of the circle officer, Barnagar Revenue Circle, Sorbo, Barpeta district, on when?
My lord, 1/2/2022.
1/2/2022
Then again on, my lord, 1/9/2022.
and 1/9/2022 for demarcation of the said land.
Now, my lord, there is a press representation before the deputy commissioner on, my lord, 6/2/2023 on same line, my lord.
For
Because we are
demarcation of the said land. Full stop. However, for demarcation of the said land, so that the boundaries could be identified.
Right.
Full stop. As the petitioner's applications were not being considered, the petitioner submitted a representation dated
6/2/23.
6/2/23 to the deputy commissioner, Barpeta,
Barpeta district.
the Barpeta district. Full stop. However, the same has also been met with the stony silence. Full stop. No, now you tell me one thing. As per that act or whatever, You have to go to the circle officer anyway.
Yes.
So you have gone to the right person.
No, my lord, that it says, my lord, it will have to be considered within 30 days, my lord.
Ah.
If rejected, then my lord, appeal provision is there. If not considered also, she will have to prefer appeal within our next 30 days.
Okay. Person.
So, my lord, I will file a fresh, my lord. Let them consider it, my lord, from the very beginning.
First. Mr. Bigogoi submits that as the petitioner was not aware, submits that in terms of the Assam Right to Public Services Act 2012, hereinafter referred to as the 2012 Act, which provides for delivery of notified public services to the people of the state of Assam, the demarcation of land by the circle officer had to be done within 30 days. And thereafter, an appeal could have been preferred under section
8.
under section 8
My lord.
of the 2012 Act. He submits that as the petitioner, as the petitioner's representation for demarcation of his land has not been done till date, the petitioner may be allowed to file a fresh representation under the 2012 Act for demarcation of his land. Next para. Mr. N. Goswami, Learned Counsel for the respondent number
2 and 3.
2 and 3, and Ms. G. Hazarika for respondent number 1. Submit that they do not have any objection to the prayer made by the petitioner's counsel. Next para. I have heard the learned counsels for the parties. In view of the office memorandum dated 21/12/2020 issued by the government of Assam in the Revenue and Disaster Management Reforms Department has declared demarcation to be one of the notified services under section 12 of the 2012 Act.
Section 4.
Huh?
Under section
Section
4.
4,
Section 4.
notified.
Section 4. That's what I said. And as the petition, and as such, the petitioner is entitled to have his land demarcated under the 2012 Act. Full stop. As the petitioner was not aware of the 2012 Act earlier, the petitioner is given the liberty to submit a fresh representation to the circle officer, Barnagar Revenue Circle, Sorbhog, Barpeta district, for demarcation of his land in terms of the 2012 Act, within a period of
It's 30 days, my lord, prescribed early.
no, your application
My lord, Lordship may give us 2 weeks, my lord.
within a period of 2 weeks from today. Full stop. Thereafter, the circle officer shall, no, thereafter the respondent shall act upon the representation of the petitioner in terms of the 2012 Act. The writ petitions accordingly disposed of.
We agree, my lord.
Yes.
Yes.
What do you want?
My lord, a direction, my lord, for shifting the center, my lord. Anganwadi center from the present place where it was not set up, my lord. And I want direction to shift it to the place where it was initially set up. I am.
So earlier the Anganwadi center was there in one place,
Yes, Lord.
then it was shifted out,
My lord, shifted illegally.
shifted
And that too
illegally.
on the pretext that, my lord, the place where it was set up, my lord, that was eroded by, that village was
Huh?
eroded by river. The
That-
respondent number 6, my lord, who is the worker of the center, my lord, she shifted the center on the pretext that, my lord, the village where it was set up, my lord, that got eroded by river. But actually the village is intact, my lord.
That village is still there.
My lord. Annexure 11 is the, my lord,
Heard Mr.
A. Ali.
A. Ali, learned counsel for the petitioner, who submits that 195 number Bhura Kata Pam Aganwadi Center was earlier located at Bhura Kata Pam under 50 number Palash Bari Legislative Assembly constituency, Kamrup district, Assam. First up, however, the respondent number 6 conspired with others and shifted the said Aganwadi center to Udmuri village under Chaigaon Legislative Assembly constituency, purportedly on the ground that Bhura Kata Palm village had been eroded by the river. No, just say due to erosion of the due to the disappearance of Bhura Kata Palm village due to erosion. So, the petitioner's counsel submits that the Bhura Kata Palm village is still in existence and has not been eroded by the river. By which river?
River Brahmaputra.
By the river Brahmaputra. Issue notice are returnable in 4 weeks. Mr. N. Goswami accepts notice on behalf of
1 to 5 block.
Huh?
1 to 3, 4, 5 block.
1, 2, 3, 4, 5. Petitioner takes steps for service of notice upon the respondent number 6 by registered post with AD within 3 days. List them at after 4 weeks.
My lord, I had one interim there.
What interim prayer?
Because my lord, since 2020, my lord, the beneficiaries of the children are not getting any items from the center.
Acha, when was it shifted to this other new place?
My lord, it was in the year 2017.
2017.
But
Two- Just a minute, 2017.
my lord,
Have you submitted any representation to the authorities?
my lord,
Where?
my lord, we are continuously submitting, my lord, but the last one is on, my lord, 13 to 2023. my lord. That your lordship will find it as number 16.
Anyway, okay.
Of like,
2000, shifted into 2017, huh? 2017.
I have a limited prayer, my lord, to consider the representation, my lord. I do not have.
What is this item?
My lord, 9 lordship. That's to consider the representation, lord. I do not have any intention to interfere at the limitation process.
What is your case?
My lord, limitation was not done initially for a long time, my lord, and rotation was not done, my lord, from ST constituency from Jaigaon to Gulakat, my lord. Petitioner has submitted representation, my lord. My lord, now delimitation process is going on, my lord. So, my lord, I am praying that
Since the delimitation is going on, I think the case is very premature.
My lord,
It has to go on, then they will come arrive at a finding. He can challenge.
You filed it before the authority.
my lord, we have submitted representation.
Huh?
We have submitted representation.
So has the delimitation been completed?
Now yet going on, my lord. I
Then
have
for which area?
My lord, entire Assam, lord, going
Then-
on, my lord. My lord, I have
Then where is your case? You approached them. Then no right of yours has been violated.
submitted.
Huh?
We submitted representation, lord, that may be considered.
So
my-
that they will consider, lordship, because
That is my.
there are so many representations.
Yes.
They will go through it.
Correct.
Then thereafter the finding will come. Now, he is seeking a direction from the court, which he ought to
Go there.
avail before the authority.
When there is a delimitation exercise going on,
Now going on, my lord.
if it's going on, then what is your grievance?
My lord, we have submitted representation that may be considered.
So it will be considered. Where is your submission that where is it that it's not being considered? Which constituency?
My lord, Gulaghat, my lord.
Huh?
Gulaghat, my lord.
Golaghat,
Bukakhat, my lord.
Bogaghat.
Bukakhat and Dergaon, your lordship.
Huh?
They are eventually referred to Bukakhat and Dergaon.
Huh?
Bukakhat and Dergaon, your lordship.
Delgaon.
They want to shift it as regard which are SC reserve constituencies, your lordship. That is their grievances, but they have filed their representation in the way back in 2020. your lordship. Now delimitation is continuing from 1st of January 2023, your lordship. And this now recently it is going on, and recently in the last week, your lordship, of this on the March month, they are considering all the representation what every person concerned citizens are giving them, all associations, and they are saying that we'll go thoroughly and we'll take into consideration every aspect. After that, it will come down. This is a premature petition, your
Only
lordship.
then if they are considering.
All right, mister, what is your name?
Is Rahman, lord.
Age?
Rahman, lordship.
Rahman, learned counsel for the petitioner who submits that the delimitation exercise of the Bogaghat and Dargaon constituency has started in the month of January 2023. Full stop. Though the petitioners had submitted representations on 10/8/2020 and 7/9/2020 with regard to the above aspect, comma, the respondents have not taken a decision on the same. Full stop. He accordingly, the petitioners council accordingly submits that a direction should be issued to the respondent number.
Yeah, lordship, the parties are also not made properly. It should have.
Huh?
The parties are also not made properly, lordship. Lordship, you see respondent number 4. Who is the respondent number 4?
My lord, we made the delimitation commission as per 3, lordship.
It has to be, the election commission has to be made a party, lordship.
My lord,
But we are not given a, neither a copy was served on us, lordship, nor our name was on the list.
You see, when the Delimitation Commission of India is there, no doubt. But for Assam, there'll be a Delimitation Commission member also, separately.
I am making the state election commission also party, my lord.
State Election Commission has got nothing to do with the constituency, assembly constituency. What are you talking about?
Lordship, even in this matter, the GAD is a necessary party. They have not made us party only. Because it's costed. And there were similar matters which have been dismissed.
Yeah, I'm dismissing it. There's no doubt about it. What have I said?
The petitioner's council submits that a direction may be issued to the respondent number.
To the respondent number 6. To the respondent number 6, according to you.
3, my lord.
3. Respondent number 3. To consider the petitioner's representation dated 10/8/2020 and 7/9/2020. First up. Next para, Mr. RKD Chaudhary, Deputy SGI, appears for respondent number.
Lordship, I am not sure, lordship. Because
Union of India, my lord.
election commission, lordship, I'll be appears for the election commission.
Actually, you are nowhere there. You're for the election commission? No.
I'm appearing for the election commission.
Okay, you're not there. You're not there, Mr. RKD.
He served a copy to me. I was informed by.
Mr.
AI Ali, your lordship.
Yeah, Ali appears for respondent number.
I am respondent number 5, your lordship. 3 and 5, your lordship. 1, 3 and 5. your lordship.
1, 3 and 5. Then who is for the state of Assam?
I'm appearing.
Mr. N. Goswami appears for respondent number.
2, 4 and 7.
2, 4 and 7. And Miss.
Respondent number 6, A.D. Gayasthar on behalf of Mr. R. Dubey. Respondent number 6, lordship. Yes.
Got it?
Election commission.
Your name.
A.D. Gayasthar on behalf of Mr. R. Dubey.
Appear for respondent number 6. Post up. The counsels for the respondent submit that the writ petition is premature in as much as the delimitation exercise is still going on. And all the representations submitted by various individuals and bodies would be considered by the Delimitation Commission prior to taking a decision on the delimitation exercise conducted in relation to Bogaghat and Dergaon
Assam.
and in relation to the Assam,
In respect to Assam.
in respect of the constituencies in the state of Assam, legislative constituencies in the state of Assam. Huh?
Legislative and parliamentary constituencies.
Legislative and parliamentary constituencies in the state of Assam. Full stop. In next para. In view of the fact that the delimitation exercise for a legislative and parliamentary constituencies in the state of Assam is still an ongoing process. Come on, this court is of the view, is also of the view that the present writ petition is premature. Further, as the respondents' councils have categorically stated that all representations submitted by individuals and various bodies would be considered by the delimitation committee, this court does not find any ground to exercise its discretion in the present case. The writ petition is accordingly dismissed.
Maybe his lordship. Should this matter lordship relate to non-payment of the contractual bill? Lordship?
Huh?
Contractual bill, non.
Yes, so what do you want?
Lordship, the bill is admitted by the respondent lordship. Admitted lordship, the portion may be seen lordship pays 19 lordship. Then now the admitted lordship, this amount lordship, but not paid lordship. Lordship, maybe a direction will be given lordship so that they can pay this amount lordship. And page 20 is the liability list lordship, they are furnished in details lordship.
I don't know. Yes, what is to be done?
Lordship, at least this notice may be issued, Lordship.
Yes,
Notice. Or maybe they should have given lordship so that they can within 2 or 3 months maybe
Huh?
given lordship.
wait, 2012. Your contract, when did you complete your contract?
Lordship, within this time lordship.
When did you complete your contract, Mr. Council? Huh?
Immediately lordship within 12 lordship.
Huh?
Exactly date I can say lordship.
I can't, which year did you complete your contract?
Lordship, as per the estimated time lordship in the year 12, yes lordship.
2012. And you filed this writ petition 2023,
Yes,
after 11 years. Heard, Mr.
I'm yes, sir.
S. Haq, learned counsel for the petitioner who submits that the petitioner has not been paid his contractual dues amounting to rupees 15,88,499, despite completion of his contract work in the year 2012. Issue notice returnable in 4 weeks. Mr. Who appears?
I for 1 lakh.
Mr. N. Goswami appears for respondent number 1, Mr. P. Naik appears for respondent number
3, Lordship.
3.
Yes.
While Mr.
RM Das.
R.M. Das appears for
All the respondents. Rest 2,
Uh,
4,
for-
5,
2, 4, 5,
6, 7.
6, 7. This is the matter after 4 weeks. To enable the respondents to obtain instructions. Respondents councils to obtain instructions.
11 is also similar lordship.
Huh?
11 is similar.
Same parties.
Party different.
Parties are same.
Party different lordship. Petition different and other party are the same lordship.
Actually, out here you say contractual amount of 19,22,967.
Yes.
Contractual work completed when?
So this is also in the same period. lordship.
2012.
Yes, exactly.
Then parties who appears for the parties?
I
Miss-
for 1.
Mr. S. Barwa for 1,
I'm 3, Lord.
Mr. P. Naik for 3, and Mr. R.M. Das for
2, 4, 5, 6, and 7.
2, 4, 5, 6, and 7. Huh? Yes, what is your case,
My
Mr.
lord,
Gogoi?
actually, my lord, I'm a full businessman. I sought for gun
Arm
license.
license.
Gun license. My lord, every report is in my favor. Your lordship will kindly see.
Page.
Your lord. 17. Your lordship will kindly turn to page 17, my lord.
Page 17. Yes, I've got it in front of me.
There is the
Issued by whom? This page 17 is issued by whom?
issued by the officer in charge, Dibrugarh Police Station.
There's nothing I cannot read. Unreadable.
No, my lord, page 17, my lord.
I've got page 7 in front of me.
Here.
Okay, this is the one. No, who has signed it? You know, this is blank.
No, on the left side. Forward.
On the left side, then what is on the right side?
Inspector OC. That is signature, I don't know. Maybe.
You see, yours faithfully is on the right, signature is on the left.
My lord, may I read the report?
Yes,
With reference to the subject cited above, I have the honor to report that I have locally verified the CA of Sri character assessment of Sri Kailash Gogoi, so and so. And found correct. I have also consulted with the available PS records, but found nothing criminal records in his name. My lord, clean sheet. He's an Indian civil bar. But I beg to report that applicant is a businessman and he has to move all the district.
2018.
Yes. See,
So what has happened since then?
my lord, Deputy Commissioner is just keeping silence.
Give us a minute. Have you filed any representation to them?
My lord,
This is so long ago. Have you,
my lord, you also guys, you also kindly see, let the direction.
No, you see, this letter is to the Superintendent Police DSB Dibrugarh.
Yes.
The Deputy Commissioner's role is not there. So we'll have to,
My lord, let the notice go at this stage. Let the notice go, my lord.
no, notice can go, but why have you kept silent for so many years?
So, my lord.
That is 2018 letter, and
But
now it's
He's
23.
saying every time he's going, but he's refused. He's saying that way.
Going to whom?
Going to Deputy Commissioner.
Why should he go to the Deputy
Because
Commissioner?
he's the licensing authority.
Mr. Council, come to page 17.
Yes.
This letter is addressed to whom?
To the Superintendent of Police.
Then, where is the letter that has gone to the Deputy Commissioner? Why should he go to the Deputy Commissioner?
Because he's the licensing authority.
Mr. Council, show me a document which shows that the papers have reached the Deputy Commissioner.
We also can see the last connection.
You see, yes, last election, yes.
Page 21.
Page 21, yes.
To the District Magistrate, Dibrugarh. Madam, I am directed to send here with the gun petition in respect of Sri Kailash Gogoi.
Which page? Page
Page 21.
Yes.
Duly recommended by Superintendent of Police, Dibrugarh for favor of kind perusal.
Okay. Okay, right. Heard Mr. D.R. Gogoi, learned counsel for the petitioner, who submits that the petitioner has applied for a gun license with the respondent number with the district magistrate is not a party.
Yes. Yes, or two,
Deputy Commissioner
my lord.
with the Deputy Commissioner / District Magistrate Dibrugarh. Full stop. He submits that the Deputy Superintendent of Police, DSB, Dibrugarh, had issued letter number DSB full stop DBR full stop Roman 9/arms/2018/62 dated 25/06/2018 to the District Magistrate Dibrugarh, stating that he had sent the gun petition submitted by the petitioner duly recommended by the SP Dibrugarh for his perusal. He submits that till date, no action has been taken on the petitioner's no action has been taken by the Deputy Commissioner / District Magistrate Dibrugarh for issuing the gun license to the petitioner. Issue notice to the respondents returnable in 4 weeks. Mr. S. Barwa accepts notice on behalf of all the respondents. Full stop. He shall obtain instructions from the Deputy Commissioner / District Magistrate Dibrugarh as to the fate of the gun application, the gun application made by the petitioner, keeping in view the letter dated 25/6/2018 issued by the DSP, DSB, comma, Dibrugarh. Bracket page 21, huh? List the matter on. Give a date. May.
Yes,
10 May.
yes, can we? Oblige, your lords.
My lord, I beg apology from this honorable court because in the morning I have done a minor sense in the writ petition without permission of the court.
You see, Mr. Counsel, you cannot change
Yes, my
the
lord.
writ petition as you like, the names.
Yes, my
You
lord.
see, these are all uploaded in the system.
Yes, my lord.
When you make a change in the names,
Ah,
then what happens later on, it doesn't match with the system.
My lord, I may kindly be pardoned, my lord. I have done mistake.
This is not the way to do
Yes,
things. Why do you have to do something so, surreptitiously? When all you have got to do is ask, and there's no problem with making changes.
My lord, I may kindly be pardoned.
You, thank God we saw you doing it. Otherwise, we would have a problem in the evening while uploading the orders.
My lord, may I go to the text, that is?
Yes,
My lord, the petitioner was issued credit card without his recent written consent, without application. And my lord, the petitioner is a registered contractor of the PWD Assam and has been entrusted with the construction of 2 routes in Nagaon district, and he has applied for loan. Therefore, the petitioner, my lord, since October 2022, petitioner has been via different link applied for the cancellation of the card, but it was not cancelled. Sometimes respondent on court, that is SBI card, said that it would be cancelled. Sometimes say that it had been deactivated. Sometimes say that no, it cannot be resolved in your favor. Thereafter, ultimately, my lord, they said that he has a credit card balance of rupees 3,166. He also paid it, but it was not his consent to the card.
anyway, so basically you want the credit card to be cancelled.
Cancellation, my lord, because the CIBIL score has fallen down. and
What has fallen down?
CIBIL score, my CIBIL score has fallen down. As a result, bank has declined to release my loan, which was already sanctioned. Therefore, I have suffered a lot, my lord. There is violation of my, not only legal rights, there is violation of fundamental rights also. Under master direction of Reserve Bank's credit card and debit card rules, my lord, unsolicited, the issue of unsolicited card is prohibited. And if there is any request to close any credit card.
Yes, why is yes, credit card?
I'm only for respondent number 1, my lord. Notice may go to the.
Okay, right. Heard, Mr. LP Nath, learned counsel for the petitioner, who submits that the petitioner has been issued a credit card by the SBI,
Yes.
by the respondent number
4.
by the respondent number 4, without the asking of the petitioner. First off, he submits that despite the request made by the petitioner to cancel the credit card, the respondent bank have not cancelled the credit card. First off, issue notice returnable in 4 weeks. Ms. A. Gayan accepts notice on behalf of
Respondent number 1.
one,
Respondent number 1.
only one.
Only
Only one. What about Governor, Reserve Bank of India? What is this?
My lord, actually, Governor Reserve Bank of India is made a party because all of these banks are entity under Reserve Bank of India.
So,
So Reserve Bank of India is also made a party, my lord.
what?
All of these banks are governed by Reserve Bank of
I
India.
think I'll have to look at your case more carefully.
Yes, my lord.
Yes.
My lord, actually, civil,
I just
There
say issue notice to the respondent number 1, Chairperson, State Bank of India. Managing Director. Your bank is, what is the branch? Where do you have your account? Which branch?
my lord,
You're all the high ups you have made parties. But from, from where do you take your money? Little bit, 100
My
rupees,
lord,
200
actually,
rupees.
it was a contact over telephone, my lord.
Contact over telephone.
Yes, my lord. Thereafter, they offered me the card, but I asked them only to send the terms and conditions. The cards. In the
Mr.
card,
Counsel, where do you have an account? Which bank, which branch?
no, my lord, this is SBI Card and Payment Services Limited. It is in the card, it is mentioned that SBI Card and Payment Services Limited. And
So you have direct contact with RBI and with the Managing Director and Chief Executive Officer, Cyber City, Gurgaon.
yes, my lord, SBI Card and Services is held by SBI.
Do you have any account in a normal bank branch like us? I mean, or
this-
do you have account only in the head office or something like that?
This account is, my lord,
Let me see your credit card. Mr. Counsel.
Here it is dictated that DLF infant. No, my lord, not against any account, my lord. In case of this credit card, the account number is 653003. This is, my lord. Not against any bank account, my lord. In case of credit. card,
I know, not against any bank account, but you must be having a bank account in some branch.
I receive it through via post, my lord. Not
Correct.
online.
But you have to have some bank account in some SBI branch.
I have bank account in SBI branch, my lord.
Where is that branch? Which branch?
I have no instruction, my lord. The card is not issued from here, my lord, not from Assam.
Cut that order, huh? We'll place it again. I think we have to, there is something missing in your petition.
My lord, credit card is not issued against bank account, my lord. A account is itself created by the credit card, my lord. And a person, when
I don't know. Is it possible? I don't know. What do you mean?
he has to pay from
You have been given a credit card from whom? By whom?
this account is created by this in this credit card.
Online fraud, my lord. He is also victim, my lord.
Huh?
He is also.
Online? Fraud.
These are online fraud, my lord. Actually, no.
Okay, oh,
This
okay.
is not joined to any account, my lord.
It is like an online fraud. It happens, Lord. It is happening.
Okay. So
My lord, page number, the
what
address
did
is
we say?
given
What
as
did we say?
Issue notice.
Huh? What? Issue notice?
Issue notice.
Issue notice. Returnable
I have
exception.
another prayer also.
Miss, again, accept notice on the respondent number one. Petitioner takes steps for steps for service of notice upon the respondents number 2 to 6. Within 3 days. List the matter on. List the matter after 4 weeks. Asha, on the prayer of the counsel for the petitioner, he is allowed to make correction to the writ petition by hand during the course of the day. Now we have corrected the anomaly made by you surreptitiously in the morning.
My lord.
Okay, 1 minute.
They were issued once, nobody appeared, and thereafter, my lord, all the matters are in the cold storage.
This for mutation
Yes, sir.
in the land record.
Land. So, my lord, the applications are there, then he subsequently filed representation. Of course, my lord, during that COVID time, nothing proceeded. But thereafter also, my lord, in spite of his approach being made, my lord, the matters are not proceeding. My prayer would be, my lord, let my friend have the instruction or your lordship may issue notice.
What about that Public Services Act? Does it come, is it applicable for mutation of land record?
I'm not sure.
My lord, we have enacted our own act, my lord, Karbi Anong under the sixth schedule, my lord, we have the power to act, my lord. We have enacted our act. As per the act, my lord, we have the power to mutation, my lord. And my lord, why the mutation has not been, I'll take that. Mutation, why the mutation has not been done, my lord? Mutation means, my lord, registration in the records of right, my lord. I'll take instruction, lord, may issue notice, my lord, within 4 weeks, my lord.
No, but why haven't you done it?
Well, I have to take the instruction, why that has not
Okay,
been done.
right. Mr. M.K. Chaudhary, learned senior counsel for the petitioner, submits that despite the petitioner having requested mutation of his name in the land records, the respondents have till date not completed the exercise. Mr.
J. Sutia,
J. Shutia appearing for
all the respondents.
all the respondents submits that he will obtain instructions with regard to the same. List the matter on.
After vacation, leave vacation.
First week of May,
Huh?
First week of May, convenient.
Okay, 1st of May, 1/5.
First week, my lord, I think.
Second,
Already.
no, not second. Second is third.
My lord, in this petition, my lord, the petitioner was settled with the fishery. And during the subsistence of the, my lord, period that is expiring today, he filed application for extension on the ground of having suffered loss. And there was an inquiry, and the inquiry report has also in favor of extension. Because under the rules, my lord, extension can be given. What I pray for is that, my lord, your lordship may dispose of this petition and decide it either way.
Notice my.
No. Why don't you go will dispose of? You decide the issue. Why notice? You decided within a week or within 10 days or whatever. Whether you want to extend, because you see, today it's ending. So you decide whether you want to extend the fishery or not. That's all.
Lordship, I think.
That discussion, my lord. The exercise is a discussion, whether to give it or not.
He wants a decision, that's all. And even this court wants a decision.
Lordship, there is a report from page number 12, 45, Lordship.
45.
That is the
There
report of
they
the
have a
Honorable Circle
report,
Officer.
Lordship, from the government.
Huh?
That is the report of the circle officer.
Yes.
It was, my lord, an inquiry conducted pursuant to the direction of the Assam Fishery Development Corporation. And last paragraph, your lordship will see, considering the above facts and in the greater interest of the youth and families associated with the bill, I would therefore request you kindly authority to consider the prayer extension as per existing rule. That is the recommendation. So they have to
You take a decision. You can say yes or you can say no.
True.
That's all.
Yes.
What is the use of issuing notice? At the end of the day, you have to take that decision anyway. Heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. Kama, who submits that the petitioner had been settled with the Haribanga Mean Mahal
In the Nagaon district.
in Nagaon district for 7 years,
Which is coming to an end.
which is coming to an end
Today, my lord.
today. He submits that as the petitioner had suffered loss during the settlement period, the petitioner had prayed for extension of the settlement period. He also submits that the circle officer, Samaguri Revenue Circle, Nagaon, had written a letter dated 15/2/2023 to the Deputy Commissioner Nagaon, requesting the authorities to consider the prayer of the petitioner's prayer for extension of the settlement of the fishery.
We should address to.
Huh?
Address to respondent lordship,
Huh?
address to the AFDC lordship, copy. Then later for.
Full stop. The said letter dated 15, now a copy of the said letter dated 15/2/2023 had also been addressed to the respondent number 2. Full stop. The petitioner's counsel submits that the writ petition can be disposed of with a direction to the
Number 2.
to the respondent number 2 to take a decision as to whether the settlement of the Haribanga Mill Mahal can be extended for
But considering considering the report, my lord.
For 1 year.
Clear.
1 year. Full stop. Full stop. Next, Mr.
Petition.
P. Sharma appearing for
All the respondent.
1, 2.
1, 2, and
One and
Mr. S. Barwa appearing for
3 and 4.
3 and 4. Submit that they have no objection with the prayer made by the petitions counsel. In view of the consent of the parties, the respondent number 2 is to take a decision on the petitioner's representation for extension of the Haribanga Mill Mahal and communicate the same to the petitioner within a period of
15 days, my.
3 weeks.
Huh?
3 weeks lordship.
within a period of 3 weeks from today. The writ
After
petition
submission of the certified copy lordship, they have to sign.
at 3 weeks from today. Okay, from the date of submission of a certified copy of this order. Full stop.
To the
The
I'll submit it to the respondent number 2.
the petitioner shall submit the certified copy of this order to the respondent number 2 within a period of 1 week from today.
I have.
The writ petition is accordingly disposed of.
May it please your lordship. Lordship, the petitioner was initially issued with a notice, lordship. As the GST authorities, they have found some discrepancy of his payment of tax, lordship. After they are going through the income tax return filed by the petitioner, lordship, petitioner company. Then lordship, he was issued with a notice, lordship, to provide documents on this. And then he filed a reply on 8/10/20.
Where is the impugned order?
Lordship, impugned orders, the last being the,
Page 77.
yes, lordship. I have impugned page 76 also and the page 77 because they arbitrarily changed the jurisdiction, lordship. Jurisdiction of the commissionerate. My jurisdiction is that Dibrugarh and Tinsukia. They have arbitrarily violated this page 76, lordship, annexure 5. They have arbitrarily changed the jurisdiction, lordship, and that too during the COVID period. So I made a prayer, and they in the page 77, the impugned final order, lordship, by the their lordship, they have stated that they have sent me some notices for personal appearance, but which were never been issued and which were never been received by me, lordship. And they have passed this. And before that, lordship, kindly peruse.
Why don't you file an appeal?
Lordship, because he already has stated that the lordship, kindly peruse the reply filed by the initial reply, lordship, dated this one 8/10/22, annexure 3 page 71, lordship. Lordship, service tax rule introduced payment of service tax under reverse charges method. I'm just reading the letter, lordship, with effect from 1/7/12 and Indian Oil Corporation Limited, as per circular number so-and-so dated 7/6/2012, declared the responsibility about payment of service tax under reverse charges method. So reverse charges method, lordship, the service recipient and the service provider both share the GST, and this is there which I have annexed in Annexure 2, lordship. This is the circular issued by the Indian Oil Corporation Limited, lordship. And as per the services, sometimes they have to pay nil taxes, sometimes they have to pay 50%, 25%, like this, lordship. Responsibilities are divided as per the nature of work they execute, lordship. So they have stated that following the terms of reverse charges method, my establishment
Look,
already.
madam, you are challenging
Lordship,
this page 76 and page 77,
7, lordship.
correct?
Thereafter, I
Now,
filed
there
a
is-
representation, lordship,
Just a minute.
lordship,
There is an appeal provision
lordship.
and there is a division, then there is a division bench judgment of this court. Which has relied upon a Supreme Court judgment.
Lordship, then I am praying for a liberty, lordship, so that I can approach this,
Yes,
lordship.
yes. Miss M. Bhattacharya, learned counsel for the petitioner submits that in view of the judgment of the in view of the order dated 20/03/2023 passed by the division bench of this court in WA number 188/2022. Which has upheld the decision of the learned single bench that the writ petition was not fit to be entertained in view of the existence of a statutory remedy for filing an appeal being available. She would like to be given she would like to file an appeal. She would like to withdraw the writ petition
Lordship,
with liberty being given to approach the
appellate forum.
to take recourse to the alternative remedy available. Mr. S.C.K.L. learned counsel for the GST submits that he has got no objection to the prayer made by the petitioner counsel. In view of the order dated 20/02/2023 passed in WA/188/2022. And the decision of the apex court in Assistant Commissioner of State Tax and Others versus Commercial Steel Limited, reported in 2021 SCC Online SC 884, the petitioner, the writ petition is closed as withdrawn,
Lordship, with the liberty, lordship.
with liberty being given to the petitioner to avail of the statutory remedy available
Lordship.
by filing an appeal before the competent authority.
Lord. Deployment.
May it please your lordship. Your lordship. the
Demarcation.
Demarcation, lordship. I'm only requesting for your lordship for disposal of my application as per law. They may take a decision. My representation is at page 54, your lordship.
No, you see, so as per the act, you have gone there
Format.
to the circle officer.
They, your
Huh?
lordship may direct them to take a decision within 2 months to dispose of the
It has to be done within a month,
within
actually.
month.
And otherwise, then you're going to file an appeal. Then you file an appeal. And you have already taken recourse to that alternative remedy.
They have not taken a decision. Your lordship. may-
Or we can ask him to file a fresh application.
In fact, this is a plain application. He ought to have filed in the standard format which is prescribed as per the notification. So
Then
let him
this
file
will-
along with the.
You file a fresh as per the format provided in
Yes.
the
Yes.
act. Correct. Okay, heard, Mr.
Arsham.
R. Sharma. The learned counsel for the petitioners who submits that the petitioners had submitted an application in plain paper for demarcation of their ancestral land, which was inherited by them. First up, the petitions council submits that the application had been submitted before the circle officer, Azara Revenue Circle. Which district? Kamrup M. First up, however, the same has not been. However, the same has not been acted upon till date. First up. Mr. S. Barwa appearing for the respondent number
2, 3, and 4.
2, 3, and 4, and Ms. G. Hazarika appearing for respondent number 1. Submit that in all probability, the application of the petitioner has not been acted upon as he has not submitted his application in the prescribed format as provided in the Assam Right to Public Services Act, 2012. Hereinafter referred.
There is a office memorandum.
As per the hereinafter referred to as the 2012 Act and the office memorandum dated 21/12/2020 issued by the Revenue and Disaster Management (reforms) department. Next para. I have heard the learned counsels for the parties. The 2012 Act provides for delivery of notified public services to the people of Assam. And in terms of the OM dated 21/12/2020, demarcation has been declared to be a notified service under Section 4 of the 2012 Act. As the petitioner has not submitted his application for demarcation, submitted their application for demarcation in the prescribed format, it appears that the said application has not been acted upon by the respondents. Accordingly, the petitioners are directed to are given the liberty to submit their applications for demarcation of their lands in the prescribed format as provided under the 2012 Act and the OM dated 21/12/2020 before the circle officer Azara Revenue Circle, who shall thereafter act upon the same in terms of the 2012 Act. The writ petition is accordingly disposed of.
Could your lordship observe within 30 days from the date of my
I said 2012 Act, the 2012 Act provides that.
oblige?
I cannot spoon feed everyone.
Oblige. May I please, your lordship? In this matter, Dr. Ashok Sarath is leading us in this case, but
Maybe,
suddenly
no.
he had to go out of station.
Huh?
But suddenly he had to go. out of
Maybe,
station.
maybe.
But
No, I'm heard Mr. What's your name? I think first of all, this is by the additional commissioner in Mizoram. So it should have been filed there.
No, see what happened in GST, the jurisdiction has been transferred to some other officers because of heavy nature of work.
Correct.
So it may be under the Demarcation commissioner. So it may be filed before this.
Correct. Okay, before the commissionerate is same.
Yes, commissioner.
But that way.
Jurisdiction has been distributed to-
But then there's the appeal provision.
yes, that is
The appeal provision is there, I think section 85,
yes, it is
service tax.
like 17 item 17.
Like item 7. But what is the specific section for appeal?
Lots of 85.
85, no? 85 of the,
Finance Act 1994.
what is the,
I'm
Also kindly accommodate with a single day, Lordship. Can it be a Monday, or Lordship?
It will be 84 lots.
84,
Finance Act.
84 of the
Finance Act 1994.
Finance Act
1994.
1994.
It will be like to the Commissioner Appeals at Guwahati Road.
Huh?
It will be like to the Commissioner's Appeals at Guwahati Road. It is provided in paragraph.
Allied to the Commissioner Appeals,
Appeals Lordship.
Guwahati.
Got it. Page 63. Order indicates.
Okay, so he wants his senior to be there.
Yes, your Lord.
We'll fix it on Tuesday.
Lots.
Monday, I think we've fixed too many.
Okay, your Lord.
Yeah, we'll fix it on Tuesday, but then if he doesn't come on that day, we're disposing it of.
Lots.
Deeply obliged, your Lord.
That's a minute. Heard Mr.
PK Bora, your Lord.
PK Bora, who submits that as his senior Dr. Ashok Sharaf is having some personal difficulty, the matter may be adjourned. Mr. S.C. Kayal, the learned counsel for the GST, submits that the writ petition should be dismissed as an alternative remedy is available. He submits that the impugned order can be put to challenge under section 84 of the Finance Act 1994. And in view of the order dated 20/02/2023 passed by the division bench of this court in WA number 188/2022, the petitioner would have to avail the remedy of appeal provided under the Finance Act 1990. In view of the prayer made by the petitioner, leaves the matter on 4.
May I please, ma'am? But the petitioner before your lordship is a self-help group, my lord. They were settled the my lord Fishery for 7 years, ma'am. My lord, they
Expired, their term expired last month.
last month, my lord.
Yeah.
Prior to that, I have filed a representation, my lord.
Now what remains?
My lord, prior to that, I have filed representation.
So let them decide that.
Yes,
That's
my
all.
lord. Let them decide the representation. And my lord,
what?
they have not floated yet, my lord. No tender has been floated yet.
But if your lordship goes into the representation,
Ah,
I think, I'm afraid the deputy commissioner would be in a better, will be in a better position to deal, how to deal with this matter, because he refers with regard to one other case whereby an unsuccessful bidder has a challenge before the court. So he is praying that he may be allowed the resettlement till the survival of that case.
hmm.
So how do we decide upon this
Where
kind of
is that?
representation?
Page 22.
22, my lord.
22. The last. Apart from the COVID period and
I may be allowed to, my lord, file another.
the fishery is now
representation
not
about this,
in a position to operate due to heavy grass on it. So it is very much necessary to clean the fishery. It is therefore prayed that the fishery may be resettled along with the petitioner's self-help group till the end of the case. So here, this case, from the body of the petition, I could make out, it is with regard to that case which has been filed by the unsuccessful bidder.
There is a case pending, my lord, that I'm not on that,
Then
my lord.
thus prayer be entertained by the deputy commissioner.
Prior to that, my lord, the main portion of the.
Can the deputy commissioner decide that?
This
Who can give extension of fishery?
this is by the deputy commissioner, my lord.
No, who, the settlement of the fishery
Yes, ma'am.
in the first instance was done by whom? Done by
Lord,
which authority?
My lord, this is
Fishery department.
Fishery Department, my lord.
Fishery Department.
Government of,
Now, can the deputy commissioner have any role to play?
my lord, I may be filed a representation to the government.
That you find,
that is
that we were.
I have also filed, my lord, prior to that, I have also filed a representation to the government, my lord. That is also pending, my lord, but I could not annex the representation here, my lord.
No, we do not know, Mr.
My lord, your lordship will find, my lord, my statement.
He may
page
withdraw and file
paragraph
fresh,
Huh?
he may
Fresh-
withdraw and file fresh representation.
Yes,
before-
yes,
before
you
the
withdraw, you find.
But your lordship may direct, my lord, I will file it. Press.
Oh, no, no direction, no direction from us.
My lord, your lordship will find page 6, para 6, I have stated, my lord. I have filed a representation to the government also, my lord.
You might have done, you file it afresh. You
Yes,
don't know.
I have filed, my lord. I have filed to the representation.
When
as
did
well.
you file?
That is, my lord, I have a copy, but it is not there, my lord.
No case.
My lord, I may be allowed to file a representation to the government as well as DC, because DC has handed over.
Look, Mr. Counsel, you don't need permission from the court to file a representation. You want to file, you file. This court is not going to give you any permission to file when it is already there for you to file.
And my lord, I have filed.
We
also, that may
cannot,
be
you
considered.
cannot, huh?
Whatever I have filed before it, there, my lord, that may be considered.
I'm disposing this case on the basis of what is in the record, that's all.
Yes, my lord, your lordship may dispose, directed to dispose of the
Yes,
representation.
basically, I'm dismissing it because you have not filed an application to the competent authority. Heard Mr. J. Payan, learned counsel for the petitioner, who submits that the settlement of the petitioner, settlement of the number 12 Tuni River Fishery under Majuli district with, for a period of 7 years ended on 9/2/2023. 9/2 or 9/3?
9/2, my lord.
9/2/2023.
Ended on 28/2, my lord. I filed representation on 9.
Ended on 28/2/2023.
2, my lord. My representation
stop.
was 9.
The petitioners, the petitioners counsel submits that the petitioner has made a representation dated 9/2/2023 to the Deputy Commissioner Majuli for extension of the settlement of the fishery with the petitioner. Due to various reasons. No, don't say due to, just say with the petitioner, full stop. Mr. S. Barwa appears for the, huh?
All the respondents.
Appears for all the respondents, full stop. He submits that the fishery having been settled by the Fishery Department, Government of Assam, the Deputy Commissioner has no authority to extend the settlement period of the fishery with the petition. I have perused the writ petition and noticed that the petitioner has not submitted any application for extension with the competent authority, that is the Fishery Department, Government of Assam. The only representation made by the petitioner for extension of the settlement of the fishery has been made to the Deputy Commissioner Majuli, who is not the competent authority to decide the said issue, the said prayer of the petitioner. As the petitioner has not availed of the alternative remedy available by approaching the competent authority, this court does not find any ground to exercise its discretion in the present case, the writ petition is accordingly dismissed.
My lord, my lord, my representation may be considered if I find my.
He has got no authority. Why should I ask
I'll file it.
an incompetent authority to decide a case?
My lord, I have given a statement that I have filed a representation to the government. My lord, I could not give the date, my lord.
No,
There are six, my
That
lord,
is
this specific statement is there.
everything that you say in an affidavit does not have to be believed by the court.
That is true, my lord. Only fair, my lord, there is an observation that I may be given, my lord.
We told you in the beginning, you do not want. Next.
May I please? My lord, this is with regard to a cooperative society. My lord, my lord, this board of directors are before your lordship.
Yeah.
My lord, we had first held the meeting on, my lord, the first meeting was held on 27/8/2016.
Yeah.
We have a period of 5 years, my lord.
Yeah.
It would have come into an end on 2021.
Yeah.
So, my lord, accordingly, we started the preparation for holding the AGM. But, my lord, because of the COVID protocols, we are around 3,000 plus members. The deputy commissioner did not allow us. Then, my lord, we approached this honorable. During the pendency of that proceeding, my lord, in the initial stage itself, they come up with a notification that we have been given an extension for 6 months till 2022. Accordingly, my lord, we immediately write to the deputy commissioner that to hold the AGM. The ARCS forwards it to the DC refuses. Thereafter, my lord, the refusal.
Who refuses?
Refused by the, my lord, deputy commissioner because of COVID. Because 3,000 people would be there. Thereafter, my lord, we again take a resolution that we will hold the meeting on 1/3 because we came to learn that from 15 to 2022, the government has withdrawn all COVID protocols. 15 days time is required, my lord, for the process. This, my lord, was refused to be done by the ARCS, saying that you have not held the meeting earlier. Now you will not hold the meeting. We will not permit you because you have not been extended. Then we approached this honorable court by 1662 of 2022. This honorable court protects us by saying that no coercive action. And therein, my lord, in the next subsequent days, the court says that we will examine as to the effect of 130, which was 130A, section 130A, which was incorporated in the Cooperative Act. Now, this matter is pending, my lord. Interim orders continuing till date. Now, what they do, my lord, they issue an order. That's the most interesting part, my lord. At page, my lord would find it at page 118, my lord.
Yes.
Peruse the letter of so-and-so, dated so-and-so and so-and-so. On perusal, it appears that the following cooperative societies under Dhubri subdivision are not able to conduct AGM and election as per provisions of the Assam Cooperative Act due to COVID-19 and due to the High Court matter for which these cooperative societies have attracted automatic dissolution under article under section 39 of the Act. And accordingly, my lord, at page 119, my lord, serial number 2, one departmental officer has been asked to manage the works. Now, my lord, the issue is before this honorable court. This honorable court is in session of the matter. There is an order, no coercive action. My lord, if my lord directs that today we have to notify the election, we are ready. But it's because of the departmental authorities, we have not been able to hold the election. There is no fault on our part, my lord. It is because of the situation. And 130, the wording of 130, which the honorable court in that series of matters is going into is, there are two parts, my lord. One says 6 months at one time, then another 6 months. It has another part that the government has the power, according to the situation, to deal with the situation according to the circumstances. There are two parts, which we say there are two, they say it's one. This matter is before this honorable court. Is in session, and there was a direction that no coercive action. On the last date, my lord, we have written in the writ petition, but the number was not given. A contempt petition has also been filed, my lord, and notices have been issued in that matter. If my lord wants the orders, I can place the orders, my lord. It starts at page 77.
One prayer. My lord, had I been in the place of the petitioner, I would not have continued. I requested, my lord, both the petitioner, the learned senior counsel as well as the junior, that kindly give me time only for today. I'm feeling so bad, my lord. But my lord, I requested them.
My lord,
and
it
they
was
also
his prayer.
too.
If he would have made that prayer, I would have never. He
My
is
lord,
not making that prayer, my lord. What can I do,
my lord, to make that prayer?
Huh?
I'm feeling so, my lord, unwell.
Okay.
My lord, I should get the chance to make a prayer. He came and started, my lord.
My lord, I waited, my lord. I waited for 2 seconds. Then only I started. He sat down.
Lord,
Then only I
made
started.
prayer,
I was
no
watching
problem.
them.
I don't have any problem. Let him argue.
My lord, I
I
have
will
no problem.
take
My
some
lord, I
time.
have it, my lord. If he is
Lordship will
having
hear
still,
him,
my lord will
I
have it on
requested
another
him,
day.
my lord. Lordship will hear him. I will make the argument.
No, my lord,
But
will have it on another
totally
day. I'm not-
unwell today, my lord.
We'll fix it on another.
Lordship, if
But
he is
this is
feeling
not
not
fair,
feeling
my
well, why should I?
I requested
No,
both
no,
of
if
them.
you are, yes, what is this, Mr. Senior Counsel? He is unwell.
My lord, He told he was unwell, but he sat down. When he sat down, I thought he's okay. but It's my
He
mistake.
sat down because he's unwell to stand up.
My lord, it's my mistake. I apologize for that. It's my mistake. I apologize for that. My lord,
Anyway, listen, no.
no,
Since
that's
you-
not
since you're unwell. Anyway, no, I'm just telling you because he's a senior counsel.
it's my mistake, my lord.
He should have
I
been more
misread this.
accommodated.
Personally,
I misread this situation, my lord. I misread
I'm
this
so
situation.
unwell. I don't shy away from my lord from appearing.
I
in
know.
person.
My friend
I
never
always
does.
appear in
Anyway,
person. I don't shy away.
But you seem to be very robust in your arguments. Right?
I'm sorry, my lord.
Anyway, leaving
Now
that,
I'm feeling very
leaving
unwell.
that aside,
Next week, any date, my lord.
leaving that aside.
Let them take on Monday, my lord.
Monday.
I don't have any problem.
Monday to we're fixed to Monday.
Tuesday, my lord.
Okay, leave the matter on Tuesday. On the pair of on account of Mr. Talukdar not feeling well.
That's okay.
I don't- What is it?
My lord, that matter, sealing of the go down. my
Yeah.
Was to give the notice, my lord, yesterday also it was submitted that being calculated.
Notices coming.
You give him a copy.
I will give you, I will just now received it, I have scanned it and I kept it, my lord.
Give him a copy.
Three separate officers for individual go downs.
Now, my lord, this is a show cause notice as to why penalty should not be imposed within 7 days from today. I'll give the reply. But the seal has to be opened. So they have sealed it without this notice. This is an admission of fact. This is what today's communication.
And the penalty is given in the town below.
No, they have calculated the penalty, but they have asked me to show cause. Why it should not be imposed? So how can I seal it? Seal the go downs without issuing the notice? That was my case, my lord. I was not given any notice.
So
And
we
my
open
lord-
the go down, once, let him file his answer. I will-
But once the go down is open, once the go down is open, it's difficult to realize the amount, my lord. Amount is also a huge one. Now we have calculated.
Okay, what you can do is,
No,
you
no, no.
see,
He gave a hundred,
Huh?
my son will file a representation before the commissioner.
No representation. This is a show cause notice. I'll give.
you should have given him 2 days or 3 days time only. Why you 7 days? We could have listed it next week.
Immediately, because the 31st is coming, my lord, they wanted it to have removed, go out from that particular premises.
They
Before
want
31st.
to leave the
They
premise.
want to continue the premises.
My
That's why
lord,
they-
at the
they-
same time, this company has, my lord, another go down and an office in another place in Belpura. My lord. It's not that they are leaving their business and going out from here. They'll have the record. they'll
How much,
find out
how much have they,
In, there are 3 notices.
how much,
for
what is the
notices.
total amount? You deposit some amount.
3 notices, one notice is 15 lakhs, 50,000.
50,000.
16 lakhs 50,000, there are 2 notices of 16 lakh 50,000.
Altogether, total is how much?
I have not made out the total, my lord.
In one notice, my lord, 5,000 penalty per date comes to 13 lakhs 50,000. In another, my lord, 16 lakhs 50,000, and the other 16 lakh 50,000. But they are, my lord, claiming this is a show cause notice, my lord. So, my lord, their first action itself is illegal. First action of sealing without notice and without giving the show cause is illegal.
It will be 38
Now, my
lakhs.
lord, they cannot.
How much?
38 lakhs.
38 lakhs.
38 lakhs.
For which period?
From the date of that, they have annexed the lease deed, my lord, from that particular date. There are
Now,
2
my
leases
lord.
of defined date that have been calculated from that particular date.
Because they have legally running that business, we don't know from which date particular, that we have to take that particular date, from the date of executing that lease. It comes out of 5,000 rupees per day.
Can you deposit some amount?
My lord, the question is whether the provisions they have not, my lord, stated. Only thing is they say it is under the 1969 Guwahati Municipal Corporation Act. Under what section it is issued? What is the violation? Nothing has been stated, my lord. In fact, my lord, right at this point, a little while ago, I have got a telephonic instruction saying that, my lord, some GMC persons are there on there and said that why did you go to court?
Why did you do? That's a different.
Because my lord, the act has been amended in 2021, my lord. This is the amendment position. The maximum punishment is 5,000.
This notice does not say anything, man.
That's why my lord, act has- because that's why the 5,000 rupees per day has been taken.
No. He's saying that the notices that do not contain the particulars.
The notice is the.
What has he violated?
It was running without trade license. That's the while
No, that-
inspecting, it has come out.
He is saying does not, my lord, mean anything unless the notice says. What is the violation?
What is the violation? I don't know.
There is no trade license, so that's the violation. But just
I
while
think
inspecting,
it is
there is no trade.
Nothing has been stated.
No trade license.
No trade license. You have to take out a trade license as section 180
and-
in a business.
So which is in violation of?
Section 180 is the violation. You have to take a business, ticket for running a business, you have to take out license.
It is
But
wrong, my
this is-
lord,
these
as per
are
your
go-
lordship, the
these
provisions.
Three downs are without trade license. We have taken trade license of only one office. As per section 180.
Under 180.
If there would have been in violation in the that particular trade portion, that the trade license there, then notice would have been
My
gone.
license, my lord, my frame
There the
is
higher
not very
notice has-
clear about the license by the municipal authority and the trade license. Trade license is under the shops and
No,
establishments. Act.
section 180 of the GMC Act. Lord.
So
It's absolutely
180
clear.
of the GMC Act is for license.
Really?
That is the license of the, my lord, municipality. Trade license is issued under the, my lord, shops and establishment act. What is the violation, my lord? They have to stay. They have not said, I'll show cause, my lord. I'll show cause, but what happens in meantime? Now, my lord, this itself is a proof that their initial action is illegal. Initial action of sealing it without a notice is illegal. So your lordship will direct them to open it.
Initially, they, without trade license, they are running business in the jurisdiction of Guwahati Municipal.
Where do you say? You are saying this is oral statement. What is the, what is there in the notice?
Let them show the trade license, my lord. They have shown only.
What
trade
is there
license
in
for
the notice? I have to go by the notice. Your verbal submission will not matter. This does not say under what is the violation. What is the provision under which he has issued this notice? Nothing is there. The private company, the Guwahati
So
Municipal.
how many rooms have been sealed? Three.
Three.
Three. So he's got 5 rooms. 4 rooms.
No, total lordship, there are 5 rooms.
5 rooms.
5 rooms. One is for use for office.
Two are officers.
2 are office. Okay, 2 are office. And 3 are for go down.
For the go down. That's why go downs have been sealed. There is no trade license. This is illegal. On the day of running.
Only thing I'm worried about is he says that there are some perishable items inside.
Yes, well. I have given the, my lord,
We are ready to open, but you have to
the
pay some
inventory of
penalty.
items.
Penalty had to be paid, my lord. That's why it has been sealed. They are running the business illegally.
My lord, if they wake up one morning, fine morning, and put us into difficulty without following any procedure, seal the go down. And I have given the, my lord, list of inventory.
No, but then the thing is that on the other hand, you're also you're not running the business you're running the business without a license.
My lord, we have a license. They have to show that, my lord, trade license is required. What my learned friend had shown the other day, my lord, independent go down. It's not a go down, independent go down, my lord. It is only transit storage for us. So we'll explain that, my lord, before the authorities in the show.
The agreement itself.
What
shows
happens
their
in
own agreement. This is not my document. The agreement said there are go downs.
Huh? Yes.
Their own agreement shows there are go downs.
It's not my statement. That is the lease deed here he is referring to. Anyway, my lord, I'll show cause, but what happens in the meantime?
Page number 30.
This notice itself is clear.
Schedule page number 27 and 30. Page number 27 in the schedule.
Notice
this is the
itself
go down.
is, my lord,
Page
says
number
that,
30
my
also
lord.
there
Why
are
don't you allow him to take out the perishable?
If not,
The perishables.
That can be given, my lord, that can be resealed, but they have to pay the penalty.
Huh?
When they have to pay the penalty, if required, they can pay part.
Without
penalty.
showing cause, how can I pay? Why should I pay the penalty? I have to show, I have to satisfy them that I am not liable to pay any penalty because you do not require a license. He is telling about trade license is not required.
But Lord,
He's
will
telling
grant
about the independent.
Section
Now, it is not an
180 of the
independent
GMC,
ground.
180 of the GMC, whether he requires state license or not. 180 of the GMC.
Now, my lord, this document itself is a proof that, my lord, they have
Page
acted
number
illegally.
80, Lord.
They have acted illegally in a very high-handed manner. And my lord, misuse of the.
Section 180.
Are you leaving the godown?
My
Are you
lord,
leaving the
in
building?
this fact situation, I may not leave, my lord, because I have been given the time to show cause. Your lordship will say, my lord, I'll be there till
Section
the show cause
180,
is given and they decide. to
License
make
to be taken out annually. Every person who exercises or carry out a business in the city, either by himself or by agent or representing any of the profession, trade or calling indicated in the fourth schedule. So annually take out a license before the first day or April in each year or within 1 month for taking up the profession. The business has started long back. They have not taken out. That's the illegal thing.
What
And
license?
annually he have to take it out.
What license? I have a license. I have shown the license.
And that godown is in which you showed me the schedule.
Yes.
The schedule.
Lordship will turn to the fourth schedule. Yesterday. Fourth schedule, Lordship will find it start from page number 184. And independent go down comes up in page number 194. First one.
Schedule is where? Which page?
Page 194, Lordship. This is the schedule with the category 1. We said they have to pay the maximum amount of fees for the trade license. 194, Lordship. One, independent go down.
Now let my friend show, my lord, what is an independent go down, my lord. Where it is defined in the act. Let him show it, my lord.
And the 33 is the commercial institution. Either you will find the commercial institution or it's for CNF agent. Some business is going on there. That's why he had taken out the license for the office.
This annexure 1 has to be read in connection with
And it's schedule 4.
schedule 4.
Schedule 4 is the list of businesses where you have to pay the amount, the trade license amount. In the, what will find it in the very first one, my lord.
Yeah.
Though it is the old one, my lord, now it has changed.
In the first one, meaning?
Lordship.
In the first one, you said in the
First one, but a company or association of or body
Yeah.
individually have paid up capital of which the equivalent to the 20 lakhs of rupees or upward at the trade mentioned in Annexa 1. Now he says it's a 32 billion company. It's a big company. We have to pay the maximum. Maximum here it is 7,500, but it is not 7,500. Now it has been enhanced to 9,000 some amount that he had already paid in the office, 8,000 something.
And this license I have taken, my lord.
Yes.
That
For
is
the
my
office.
deed.
I
have
think
taken
you
this
deposit
license.
some money. Then
My
we can.
My lord, now my submission is, my lord, let us come to the basics. The basics is that some GMC officers come to my premises, they seal it without any notice. Now that is on that allegation I have approached the Rush. And now, my lord, this so-called notice fortifies the fact that they had sealed it without any authority of law because, my lord, a notice has to be given first. That notice has come now. Therefore, my lord, that first section of sealing is illegal. So that has to go. Consequences will follow. And
But then notice need not be given all the time in all cases.
No, my lord, that is what the provision is, my lord. Section, my lord, 80. That requires that, my lord. Any action, they have to issue notice. Page 80, my lord, section 180. Therefore, my lord, they had sealed.
Let
my
us see when
property.
provided where.
Yeah,
Where
that
is that
provides you, my
notice?
lord. Or Mohammed, 80.
Will give a notice to the person who has taken out a trade license. Here, the person has not taken out a trade license. To whom to get the notice?
He is, my lord, again, they're telling about trade license, my lord, let them show anything in the act that it requires a, my lord, trade license.
Definitely, the
I'm
section
at the
180 is
cost
there.
of
I have shown
repetition
it,
I am submitting, my lord. That is under the, my lord, Substitution Establishment Act, not under the GMC Act. And he's telling about, my lord, trade
The
license.
section 180,
again and again.
insisting on the section 180, the trade license we have to take out when I start the business.
Where is the word
Annually,
trade license?
annually, before first of April, first week of April.
Let him correct.
Every
myself.
year. Annually, you have to take out.
Where is that notice part?
What is for this? Good.
Page 146, my lord, under the license, 378, section 378. That is the provision regarding license. Section 378. Proviso. Before any order of suspension or revocation or reasonable opportunity shall be afforded to the grantee of the license or the written permission to show cause as to why it should not be suspended or revoked. And my lord, whether there is any provision in the act or not, my lord, natural justice demands that I have to be issued a notice when you take an action. So I approach your lordship against their action without any authority of law, without issuing any notice, without making allegation as to what is the violation. They have seen the 3 proofs. And this show cause notice issued today, it, my lord, fortifies my stand that this is illegal. Once it is illegal, my lord, other consequences, your lordship, in my humble submission, need not consider. They'll have ways and means. And I am not a petty business, petty trader. I am a, my lord, 43 billion rupee company, and I have got other office in Beltola. And they can find out always, my lord, where is that office in Beltola and what is the holding number or whatever, my lord, they require. They can find out. They can, if at all, my lord, ultimately I am found to be liable to pay the penalty after, my lord, show cause notice is issued and a decision is taken, or maybe, my lord, I approach your lordship again. Then also, my lord, they have got ways and means to realize the penalty. But the question that also for consideration of your lordship is that whether the action against which I approach your lordship is illegal. And that has been proved by this document. Thereafter, my lord, other submissions cannot be made. And they have given me 7 days notice period from today. My
We'll take it up at 2. We'll take it up at 2. Let me see. Next.
Because heard the matter other day, my lord, here, my lord, I was given a mining contract with effect from 2/4/2016. I was stopped to operate the same, my lord, without any reason, my lord, for a period, lordship has earlier said.
Yes, what to do, Mr. Jyoti?
But there is no provision. The petitioner is relying on the earlier rule, my lord, 1994 rules. Now 2013 rules comes. The petitioner has stated in my lord.
My lord.
In
There's
the
provision.
That's why I'm pointing it out.
My lord, minutes.
Para 15, page 13. Para 15, page 13. The
Yes.
provision under Rule 9 of the Assam Minor Mineral Concession Rule 1994 supports the claim of the petitioner. Although there is, that rule has already been, my lord, replaced by another rule, my lord, 2013 rules, my lord.
And that point has already been considered by the honorable court, my lord. That whether there is any provisions for extension and what is the difference between extension and renewal. And there is a provisions for renewal that has been explained, my lord, and he has claimed for extension. There is no provision for extension in 2013 rule. And that point has already been decided by the honorable court, my lord.
My lord, that case is not relevant to us, my lord, because in our case, my lord, I was stopped by the authority.
Actually, you are stopped by the authority.
Yes, my lord. That case is not covered by that.
No, leaving this aside, you take a decision, that's all. Right now, he's filing a representation.
My lord.
You take a decision.
But when there is no provisions under the rule, my
So
lord.
you
if your lordship pass an order directing us to consider, my lord, reverse the rule, my lord.
Huh?
My lord,
You take a decision. Then
in
we'll see.
accordance with law, my lord. in
Actually,
accordance with the rule, my lord.
we won't say consider, you say examine and take a decision.
Lordship, examine the.
Yes, examine and take a decision, that's all.
My lord,
Yes,
my
my
lord.
lord. In the facts and circumstances that I was stopped by the authority, my lord. That may be.
Whatever, whatever. Actually, that is one of the grounds they have taken.
My lord.
That is the main ground, in fact.
Unless.
But that stopped by the authorities is only for 8 months.
That, my lord.
And
that
you have
is
asked for
considered-
3 years.
My lord, I may be considered for lesser period.
You have been stopped for 8 months, but give me 3 years extension.
My lord, I may be considered for lesser
It
period.
has to be justified.
Yes.
Your explanation also. I mean,
My
you are,
telephonic instruction is there, my lord.
Huh?
That petitioner has already extracted, my lord, only, my lord, 2 cm.
you
of the
take a
list of, my lord.
decision, you
My
take a
lord, my lord, my
decision.
lord.
That's all. So, because this issue, whether
It's
this
not
will
critical,
cover
my
or
lord.
not. You see, the problem is, there is one thing that he said, that you had stopped his operation for 8 months.
My lord, that is the another point is there, my lord, just telephoning instruction, my lord. Regarding whether, my lord, he has, with earlier, my lord, he wants to, my lord, extract the stone from the another plot of land, periodic pattas land. So that person has, my lord, obstructed. But despite that, my lord, he has extracted the, my lord, stone, my lord. After he has already extracted the stone, and he has extracting the loan, total quantity of the, my lord, stone that has been allotted to him, and he kept in other places, my lord.
Absolutely
All these
false,
things,
my lord.
my lord, I have the
Absolutely false,
instruction
my
on
lord.
We don't know, we don't
my
know.
lord, all
Anyway,
this factual part is there, my lord.
anyway,
Without
Not
any
like
inquiry, they have caught
anyway,
me.
right. Heard Mr. A.R. Sikdar, learned counsel for the petitioner, and Mr. J. Shutia, learned counsel for the BDC,
No, Kabiala Autonomous County.
for the Karbi Anglong Autonomous District Council. Mr.
Representative number 3 to
R. Gogoi,
5.
R. Gogoi, appears respond number 1 and 2.
I'm 3, 4, and 5, my lord.
Okay.
But
Then
private
you see
respondent
this
is
last
there.
order, yesterday's
My
order,
lord, just
you just take,
private respondent is there.
Huh?
One private respondent is there.
not required.
My lord. Just
So who is the private respondent? Why is he
My lord,
necessary?
the person who was disturbing me, my lord.
But
How does that matter? How is he involved now?
No, my lord.
subsequently, he made an agreement with that person, my lord, and extracting from that plot of land. I have
No,
the
my
document also. All these things are there, my lord.
Okay. That para one, you take last order, yesterday's order. What's up? The next para, the petitioner's counsel submits that the petitioner has submitted a representation dated,
My lord, my first representation.
not first, yeah, last, okay, first. Has submitted various representations to the
My lord, initially divisional forest officer Karbi Anglong.
to the forest department, comma, and the last being,
Last, my lord, an excerpt 52, that is principal chief conservator of forest,
and the, no, date,
my lord. 3rd February 2020.
and last being 3/2/2023. For granting him extension for operating the stone quarry. He submits that the writ petition can be disposed of if a direction is issued to the respondent number,
My lord,
Divisional forest officer is the authority, my lord.
principal chief conservator.
Divisional forest officer, my lord, in this. Respondent number
direction is
4.
issued to the respondent number 4
My lord.
to dispose of the petitioner's representation
Dated 9/12/2020.
dated 9/12
9/12/2020.
to 2022 for granting him extension for operating the stone quarry. Mr. J. Chutia, learned counsel for the Karbi Anglong Autonomous District Council, and Mr. R. Gogoi submit that the grant of mining contract beyond 7 years cannot be given by the respondents in the absence of any provision for extension of the mining period. First of, however, they submit that they do not have any objection to the prayer made by the petitioner's counsel for the petitioner's counsel to enable the respondents to examine the prayer of the petitioner and take a decision thereon. Next paragraph. In view of the consent of the parties, this petition is disposed of with the direction to the respondent number 4 to examine the petitioner's representation dated
9/12/2020.
9/12/2022 bracket
Annexure 12.
Annexure
12.
12. And take a decision on the same within a period of
2 weeks.
2 weeks from the date of receipt of a certified copy of this order, which shall be accompanied with a copy of the writ petition. The decision taken shall thereafter be communicated to the petitioner. The writ petition is accordingly disposed of.
My lord, till then, my lord, the queries will not be allowed to operate by other persons.
It's already.
Just much judicial protection is necessary.
Okay.
Till such.
Till a decision is taken by the respondent number 4, the stone quarry which had been allotted to the petitioner should not be allotted to any other person.
Leave love like My lord, yesterday's matter. Shall I please, sir, my lord, 5 minutes?
Yes.
Shall I please? My lord, first of all, let me take a losses to page number 74. That first clause of 2010, my lord, extension part. I'll be precise, my lord.
270,
Only 74.
page 74.
Yes. Bottom, 16.1.3.
Yes.
This is a provision for renewal, my lord. Lordship has seen that policy, right? Then this is renewal. Then page 177, new policy. That is relevant.
177.
Yes. This is also at the bottom. Bottom, my lord. Tenders that have been finalized and LOA issued prior to the date of notification of this policy, this is 2017 policy, shall be allowed to continue as per policy guidelines prevailing at that time, my time, 2010 policy, my lord. So this is Lordship has seen, my lord. Thereafter, my lord, these matters went not in this in terms of 2010 matters. Some matter went to Supreme Court, my lord. Supreme Court, my lord, Lordship, kindly see just 2 paragraphs. Is page number 23 starts, page 55. Just see the 2 paragraphs, page 55. This is regarding the caterings, my lord, of minor units like me. Keeping in view the evolving concept of social justice, we allow the members of the respondents who are the licenses to continue their petty business, especially in the absence of employment potentiality in the country on account of non-governance and non-implementation of the constitutional philosophy of an egalitarian society, which provides the opportunity to all individuals to lead a life of dignity. My lord, this is what, kindly come to the next page, paragraph 27. Relevant part I'm showing. Therefore, paragraph 27, therefore, we have to hold that the provisions of catering policy 2010 are applicable to the concerned respondents. The action of the railways in not granting renewal of the licenses to the members of the respondent is arbitrary, unreasonable, unfair, discriminatory, such and such. Next, paragraph 28. For the reasons stated supra, this court cannot interfere with the improved judgment and order of the High Court, the civil dismissed. That means what? Honorable single judge allowed the extension, division bench allowed the extension, then the other side went to Supreme Court, that was dismissed, my lord. Now, by following this judgment, my lord, there is another judgment came up, my lord, page 183. That's
Now, let's be very clear.
yes.
that this page 55 and 56 that you're reading,
Yes,
when you come to page 57,
yes.
it was passed on 29 January 2016.
I'm aware of this.
Now, prior to the catering policy of 2007.
I'm coming to it. I'm answering this one. That's why. Now kindly see page number, my lord, 183. Following this judgment came in to the page 183 on 2018. When that judgment passed with the apex court, you were very much aware about the new policy, my lord. That's all I want to say. Page number 183 starts. Lordship has seen, my lord. These are the cases, my lord. Series of cases, my lord. Operative part comes at page 186, my lord. This has been allowed, my lord. So following this judgment, my lord. Lordship will find page 185. The judgment has been quoted. Page 85 in the middle. Page 185. If the judgment of this court did not consider the case of the associations as of persons like the cooperative societies, partnership, firms, HUF, page 185.
Yes, 185.
Yes, in the middle, my lord. This court did not consider
yes,
the
this
case
court
of
did not
partnerships
consider.
court.
Yes.
Then they see the quotation of the judgment, earlier judgment.
Yes.
Manager South Central Railway, my lord, this is the case, is implemented without regard to the purpose. It would result in reducing employment but restricting the numbers of licenses to these associations of persons such as such. My lord, so I want to submit, my lord, and I want to place a lordship, my lord. When in 2018 this judgment was passed, by following 2016 judgment, this 2017 judgment was in force.
Huh? What?
When 2018 judgment was passed, by following 2016 judgment, my lord, this policy of 2017 was there.
It was there, but then it was referring to a 2000, you see, this order passed subsequently in 2018
Yes.
was only a clarification of the order passed in 2016.
Yes. Now next.
So now we have to be very clear.
I'm sure, your lordship, my lord. Please, by following these two judgments, the railway board taken a decision. Please come to that, my lord.
Okay. Let's
Page number, my lord, 230. 230. See? 2-3 judgments by the railway board had taken decisions, my lord. All over India, this has been irrevocable, except our Guwahati. Please, 230. 230. That's dated 1st of May 2019. Page 230.
Yes.
Principal chief commercial managers, all junior railways. This is reference to the order of the
200, 213, or 230.
or 230. 230. There are 2-3 orders by the railway board, my lord. 230.
Yes.
My lord, this is dated 1st of May 2019. This is in reference to the order of the High Court in series of cases, my lord. An order of Supreme Court of India 30-10-18. My lord, the other one, page 183 I have shown. And the WPC number such and such. In the contract petition, other WPC where inter alia, it has been directed to maintain status quo with effect on minor catering units like me. Next, in this regard, all junior railways are advised to maintain a status quo in respect of minor catering units as existent on 31-3-19 over Indian Railways till further orders, my lord. This is lordship has seen, my lord. Please come to the next page also. Next page also. A series of documents like this, my lord. Railway board has given extension. That is on 29-5-19. Maintenance of status quo subject kindly see, my lord. Then the most relevant one is, my lord. Next page.
Page?
Page, next page, 232.
Yeah.
This is the very, very important document of the railway board, my lord.
Yeah.
Again, principal chief commercial managers, all junior railways. Subject implementation of Honorable Supreme Court's order dated 30-10-18 in WBC number and such, my lord. Involving, third line, renewal of minor catering units on Indian Railways and order dated 10-7-19 in review petition in the matter of Union of India and vendors, my lord. This is reference to board's instruction issued regarding maintaining status quo in respect of minor static catering units as existed on 31-3-19. Since the decision of review petition by railway against the judgment of the Supreme Court was awaited, now the order dated such and such 19, Honorable Supreme Court has dismissed the review petition in the matter of Union of India such and such.
Thus, Zonal Railways are advised to ensure compliance of Honorable Supreme Court's order in the subject case and take necessary action as per the extent guidelines to renew all licenses held by the cooperative societies, partnerships, such and such. Next, kindly see, my lord. However, the status quo in respect of all other minor static catering units like me, these are, as advised by board's letter dated 21/5/19, will continue till further orders and will be subject to the orders of the Honorable High Court in Delhi, WBC, such and such, and Honorable Supreme Court India order dated and contempt, such and such. Now, kindly see the next, another page, page number 241.
241.
Yes, that's the order dated 10/8/22. Last but one page, my lord. This order dated 10/8/22, my lord. Renewal of minor catering units. Railway board's letter dated, earlier letters are referred to here. With reference to the subject above, it is observed that some divisions are not following guidelines issued by railway board, like Guwahati, from time to time, which were conveyed to the division of this office in turn. To clear any kind of ambiguity or confusion, the guidelines are reiterated below. With regard to renewal of minor catering stalls, railway board by letter dated 27/8/19, my lord, I read earlier, that big paper, one page, has issued the following instructions. Junior railways are advised to ensure compliance of Honorable Supreme Court's orders in subject case. And subject case is such and such, my lord, and then comes third, bottom, my lord, of this paragraph, last line, last part, one line. Take necessary action as per extent guidelines to renew all the licenses held by the societies, partnership and HUF. Next. However,
It is only by cooperative societies,
next,
partnership.
no,
firms
no,
and
they clarified it.
Hmm.
However, the status quo in respect of all other minor static catering units, they have clarified it. As advised by board's letter dated 21/5/19, will continue till further orders and will be subject to the orders of the Honorable such and such, my lord. This is what, my lord. And in terms of this, my lord, I have annexed copy here also. In my lord, and other parts of India, they've extended, my lord. Here I have annexed the copy also, my lord. Lordship, kindly see that page number 233. Calcutta, they have done is 436. They have done in South Central Railway, they have done it, my lord.
Where?
Two in Calcutta, they have done following this here also. Here only about the Guwahati, my lord. I don't know why, my lord. And Honorable Single Judge, my lord. There are two aspects in this matter. Honorable Single Judge, there are two single judges, Honorable, my lord. One is Justice Mehdi, my lord. The other is similar matter. Is passing order, my lord. You should notice, and has granted the stay has been granted, my lord. So my humble submission is, my lord. Coordinate bench, my lord. I should not make submission on that, my lordship is very much aware about coordinate bench, my lord, and the decision of the IPS court, and your lordship's judgment also, my lord. Since there is an order of the similar matter that day before yesterday, my lord, my humble submission is, my lord. Now have the notice and take these two cases together, my lord. Hear the matter and finish it off, my lord. And so far, my lord, so far the judgment passed by the Honorable Justice Debashish Barua, my lord. Fact of this is totally different. I have got the copies. That case started with, my lord, the area, my lord, amount they wanted, my lord. Just submit the judgment.
Anyway, we'll take it up after some.
My lord, my lord.
At 2. I have heard the other matter. Can you come and just meet me? Yes.
My lord, my lord.
As provided therein, only a clarification has been given that since they were continuing, lordship,
But what is this 7339 judgment that we don't have? No, that is it.
7339 is the
Just give this.
My lord,
Just give me this.
7339 is here with me. I have given the copy, I think. 7339, just now I have given the copy, clear copy.
that is of the area license law.
This is a area license.
Yes, that's what is
This
this.
is different.
Yes. But ultimately, also will find the persons who are involved in this will also, till today, as of today, they are continuing, my lord.
You just give me, you just ask for the records of WPC, WA 54 of 2023 and WA 47 of 23. Just call for the record.
Yes.
That will clarify.
Yes. Yes.
Both are interprets, both are WA. 54 2023 and 47 2023.
Yes. Same.
Both are 2023.
The recent cases.
WA 54 of 2023 and 47 of 2023. Just bring that. We'll take it up. Let it
My lord.
come.
Yes, my lord, yes,
Or
After some time.
after some.
after some time, my lord, yes.
The 45.
Well, I have made a mistake while calculating the amount, total amount. It is not 38, it is 46 lakhs 50,000.
Okay.
Now, I have got short submission to make, my lord. The facts emerging, my lord, in a very nutshell is that on 21st of March, some officials of the GMC came and sealed 3 rooms of the petition. There was no communication, nothing. Now, when I approach this court, today, they have filed one document, my lord. I have transferred the document since it is in vernacular. May I, my lord, place that before your lordship. I have translated it, my lord. Your lordship will kindly read how the notice has been issued. There are 3 identical notices in respect of 3 go down.
Yes.
This, my lord, does not state any reasons except that whereas you have been running the said go down without obtaining permission as provided under the Guwahati Municipal Corporation Act. As such, you are asked to show cause within 7 days as to why appropriate action should not be initiated against you for the aforesaid reason for running the go down, failing which legal action will be taken against you. Then there is a handwritten endorsement of penalty of rupees 5,000 per day. So this is issued on 31/3/2023. Now, my lord, as on the date when the action was taken, there is nothing. Therefore, my lord, the subsequent action after I approach your lordship is of no weight. Therefore, your lordship will consider my case as it stands when I approach this court and when the authorities have taken the action. The action is sealing of 3 rooms without any notice and without any information, without intimating any reason. Now, my lord, on that, I'd like to place 2 decisions of the Honorable Supreme Court. One is, my lord, 1978, 1 SCC, page 405,
1978.
volume 1, Supreme Court cases, page 405, Mohinder Singh Gill versus the Chief Election Commissioner. There, my lord, the paragraph I rely is paragraph 8. My lord, my lord, because of lack of time, I could not get a printout. I'll just hand over, my lord. I'll read a little slow and thereafter hand over. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to the court on account of a challenge, get validated by additional grounds later brought out. We may here draw the attention of the observation of both in Godhan's case, my lord. I will not read much. Your lordship will kindly read this judgment. And my lord, another judgment, the copy I could print out even good. Commissioner of Police.
In the same lines, Commissioner of Police, same line.
Yes, in the same line.
Yes. Mohinder Singh Gill, yes.
and this, my lord, paragraph 10 of the Commissioner of Police. Now, my lord, after approaching this court, and my lord, now giving a notice, and that too to show cause, the action they have taken cannot be validated. Your lordship will read the paragraph 10. Therefore, their action at the threshold is illegal, and that has to be set aside. What will be the consequences of setting aside, my lord? That they can take care of. But only because, my lord, now they have issued a show cause notice, I have got 7 days time to reply to it. Therefore, my lord, the sealing has to go, your lordship will, my prayer would be, your lordship will direct them to open the, my lord, the seats. And I'll show cause. Your lordship will keep the matter pending. I'm not fleeing away. This is my humble submission.
Execution of that particular trade from the day one is illegal without complying the section 180 of the law. They knew that they need a trade license. That's why they took a trade license in the office, keeping the go downs, not showing the go down, because this is online. Online, you have to be honest. Here, he has taken one license.
So according to you, yes, so there was no question of notice because there was no license.
Because if it had been that particular office.
Everything was illegal.
Notice.
Since everything was illegal, there was
Everything
no,
was illegal.
so,
It was a,
so there was no requirement of
the
notice.
search going on in the particular area, we found this.
Okay, right. Anything else? Anything else?
That's the.
Heard Mr. M. K. Chaudhary, Leonard Senior Counsel. Assisted by Mr. Ms. N. N. Kalita. N. Datta. Leonard Counsel for the petitioner. Also heard Mr. S. Bora, Leonard Counsel for the respondent.
GMC.
GMC
from respondent 1 to 4.
Respondent number 1 to 4. Heard the counsel at some, after hearing the counsel at some length, come on. The matter is reserved for order.
Obliged. Obliged.
These are lordship.
Put this in the file.
In item number 48, lordship, my senior legs in another court, kindly pass over the matter for the timing, lordship.
This 48, they won't pass over.
This is a application for hearing the applicant as a petition number 3, that is a co-petition.
Item 20? Two. Okay, yes.
This IA has been preferred by the MD of the company, the petitioner company. So now the MD wants to array herself as petition number 3 as the co-petitioner. This.
Co-petitioner?
Yes, there is a provision from giving co-petition. So the company as well as the director, that is my son, they have not.
I happen to be the, I am the petitioner, the company and one of the director. So.
The director
he
is my
now,
son.
The managing director wants to array himself as a petitioner also.
Why? Why not as a respondent?
I want to support the petitioners. I'm the MD of the
So
company.
you can still support while being a respondent.
Yes, sir. As co-petitioner, it's permissible or
Co-petitioner, what do you mean co-petitioner? Petitioner number?
petition number 3. I've given in the paragraph 3 of the IA. That is at page number 7.
Give me the main case. Main case. You read this last order passed by this court in the IA. Order dated 2/12/22.
I have, sorry, I lost you. I have the main case for that.
Show him this.
That was.
That
Lordship, this is actually has fallen from. There's one application was preferred. And it was suggested from the Honorable Court itself to move an application as an like order 1 rule 10. Where the court may allow.
order 1 rule 10, no problem. But since this court has passed an order in the earlier date,
That was an observation or not?
is it observation or observation?
This is what- Observation, yeah, I leave it to your lordship or your lordship, this case has been led by senior counsel, if your lordship.
Huh?
This case has been led by senior counsel.
Maybe senior counsel, junior counsel, not
No,
the
but
issue. I'm asking you about the recorded
Observation.
order. What does it say?
This observation is there, but it's not, I would say it's not a finding as such. So your lordship is keen to allow the application, then, or if your lordship is still in dilemma,
And who is for the respondents?
the state has not filed any objection. They have no.
State government, only the state is involved.
Yes, your lordship.
Any objection from the state? Give me.
They would-
Mister, give me the file. Take me the file. Yes, Mr. Barwa, any objection?
No.
No objection. Okay, right. Heard, Mister?
Arson.
Sharma, learned counsel for the applicant, who praised that the applicant, who is the applicant?
Applicant is Ms. Swapna Sharma.
She wants to be respondent number,
She wants to be the petition number 3.
who submits that the applicant, Ms. Swapna Sharma, age 56 years, wife of late Abhijit Sharma. So, page 4 it is here, page 4. Should be implemented as petition number 3. Mr. S. Barwa, learned counsel for the state government.
Yes.
And Mr.
J. Bora.
J. Bora for petition number 1 and 2. Submit that, read petition number 1 and 2, submit that they have got no objection. To the prayer made by the petitioner's counsel, applicant's counsel. In view of the submissions made by the counsel for the parties, the applicant so and so is implemented as petition number 3. You don't need to file anything. You are the wife of who? The wife of the petition number 2?
No. Petition number 2 is my son. My husband has expired. He used to own the tea estate.
Huh?
Petition number 1 company was my husband.
Okay. I registry to make necessary correction to the cost title. I is accordingly disposed of.
Much obliged.
And what is required now to be done? Nothing. So in the main case,
I think state has to file an affidavit.
in the main case, Mr. Barwa, anything to be done?
Yes, we have to file.
Okay, right. In the main case, Mr. S. Barwa is granted 4 weeks time to file affidavit in opposition. This is the matter of the police.
Obliged.
Wait, please. Sorry, Madam, advance call level not there.
Ah,
Lordship, Mr. Standing Counsel, Mr. B. Gogo is in Lakeside Court number 12.
My friend is in court number 12, I think.
so what to do?
After some time.
Next.
Let him come.
May it please your lordship, the matter relates to the obstruction of a road.
No, this 23 is for impleadment.
My lord, against my lord, I have to file affidavit, my lord, so 2 weeks time, my lord.
No, this is for IA is for impleadment or what is it?
Impleadment, yes.
So any objection to the impleadment?
My lord, yes, I have to file affidavit.
Why? Why are you objecting?
My lord, I have instruction, my lord.
You have instructions, but for what reason?
My lord, certainly, my
What are you, who has to be impleaded?
Your lordships, if I am not impleaded in this case, that I shall suffer a lot of irreparable loss and damage. Your lordships, it will be more clear from the trace map of my plot of land. Your lordships kindly peruse page number 16
Of what?
of IA. Of IA. In fact, my lord, periodic patta land, my lord, and circle officer, my lord, issued notice, my lord, for demarcation, my lord. Any dispute regarding my lord, periodic patta land, my lord, the private dispute. Your lordships, the trace map will clearly shows that 698,
Yeah.
page number 16, my lord.
Yes.
698 is my plot of land, and 687 is my adjacent plot. Just near the right side, this road is, which is shown in the trace map. This is the disputed road. This and
Which road?
in front of that road,
Which road?
approach road, my lord.
Where? I cannot see.
Just to the north corner of my plot of land, about which is disputed, my lord. And
Why do you
front of
object
that-
to him being impleaded?
my lord,
Why do you object to him being impleaded?
certainly, my lord, certain, my lord,
Huh?
telephonically, my lord, I have been instructed to obtain time for file affidavit. Your lordships, kindly may be perused, annexure D,
Mr.
page number 21, my lord. There is S. Chauhan, my lord.
Huh?
For writ petitioner S. Chauhan, my lord.
Mr. S. Chauhan appearing
There-
for the writ petitioner.
Your lordships.
Yes, what?
Very clear, your lordship. Annexure D, page number 21, it is clearly shown that the circle officer of the concerned, our circle dispute, there is a notice for eviction from government land. May I read? My lord? You are hereby informed with regard to the above mentioned subject that you have fixed an iron gate upon government land, thereby closing it in the district Kamrup Metro, Galtola, so and so, by cover doc number 628, as per report of the Lat Mundal, my lord. In respect to the same, even though notice was served to you, you remained absent for hearing, and accordingly, you are hereby informed to remove the iron gate fixed over the said government land, my lord, within 23/5/2020. If the said
Mr.
government
Council,
land
what is
not
your,
vacated,
Mr. Council, what is your grievance?
my grievance is that my entrance has been obstructed by the petitioner, my lord.
By the petition,
Yes,
okay.
my lord.
Heard,
This is-
Mr. What is your name?
Mr. A. Hussain, my lord.
Mr. A. Hussain, learned counsel for the applicant who submits that the applicant should be impleaded as a party as the entrance to the land of the petitioner, of the applicant, has been obstructed by the petitioner. Mr. S. Chauhan appearing for the writ petitioner, prays for time to file written objection. Mr. N. Goswami appearing for
Question number 2 and 3.
respond number 2 and 3, and Ms. G. Hazarika appearing for respondent number 1, submit that they do not have any objection to the prayer for impleadment of the applicant as respondent number 6. On considering the grounds for impleadment taken by the applicant, this court is of the view that the applicant is a necessary party. First of accordingly, the applicant Shri Sheshwar Bora, aged about page 2 ahead on at the bottom, is impleaded as respondent number 6. I is accordingly disposed, registry to make necessary correction to the cause title, I is accordingly disposed of. Then in the main case, you're right. In view of the order dated 31/3/2023 passed in IAC number 504/2023, Shri Rajeshwar Borwa, so is impleaded as respondent number 6. Mr. A. Hussain appearing for the respondent number 6 is granted how much time for affidavit? Is granted 3 weeks time to file affidavit in opposition. List the matter after 3 weeks. Let's finish this first. This 24. Let's finish 24. Let's finish this impleadment.
The I for application for impleting the new incumbent, earlier one retired from service.
Okay, right. Heard, Mr.
US Borgo.
U.S. Borgohain, learned counsel for the applicant, who submits that as the earlier, as Mr. Alok, as the respondent number 1, is it?
1.
As the respondent number 1 has retired from service on 31/12/2022, the new incumbent to the post of chief engineer bracket I/C bracket post PWD, SM, border roads and NEC works. Para 5, Mr. Jayanta Kumar Goswami should be impleaded as the respondent number 2. Prayers allowed. Mr. Jayanta Kumar Goswami is impleaded as respondent number 2. Registry to make necessary correction to the cause title, I is accordingly disposed of. Then in the main contempt, you write, in view of the order dated 31/3/23 passed in IAC number 857 of 2023, Mr. Jayanta Kumar Goswami, chief engineer bracket in charge is impleaded as respondent number 2. Issue notice to the respondent number 2. Petitioner to take steps for service of notice upon the respondent number 2 by a registered post with AD within 3 days. List the matter after 4 weeks.
Always.
They are not here. Anyway, let me see. This is it WA or WP? Why WA? I said this is the main. Okay. WA 54 is the one against 5143. Yes, so 54 is against 5143.
My lord.
But 5143 has not been
Now, please.
disturbed.
Yes, in this judgment, the operative part, the quoted part, my lord. Let us read from para 8,
Yes, sir.
quoted part, not isolately.
47.
Yes.
Let me see 47. 47 is against. Five, 313.
5313.
47 is against 5313 of 70.
No, let us lordship.
Just a minute.
Yes.
So in this 5313, 2017, again, judgment passed on 24/1/2023. The court has held that the catering policy of 2017 have already been implemented throughout India. And as stated by the learned counsel appearing on behalf of the respondents number 1, 2, and 4, the catering policy of 2017 have yielded good results. Under such circumstances, the question of interfering with the catering policy of 2017 does not arise at all. Considering the above, this court finds no merit in this instant petition, for which the instant petition stands dismissed. The interim order stands repeated. In terms with the catering policy of 2017, the right to renew had been taken away. So this is, I want this copy, this photocopy of this order.
I got it.
Or you're going to print it out.
I got it. I can make my submission on this. I understood it.
Okay. This 5313. 7.
This was carried to the division bench, my lord.
Both.
Yes. Now let us see the operative part, not only one paragraph. Let us see from paragraph, quoted paragraph 8.
ये नहीं ये छोटा वाला हाँ
Yes,
My lord. The division judgment, my lord.
which one?
Division judgment. Writ appeal 54.
54.
Yes,
Writ appeal 54.
yes.
Ah. Yes,
Now let us see from quoted para 8.
yes,
Yes, let us see from here, my lord. Let me read, my lord.
yes.
Although Mr. Chaudhary, learned deputy such and such, in raising an objection to such submission of Mr. Majumdar, learned senior counsel, but on principle, we use no reason as to why the said submission should not be accepted in law. We take note of the particular factual aspects that although the licenses of the applicants may not have renewed or extended, but respondents in the review authorities continue to accept the bending fees at the existing rate on regular basis without raising any objection, meaning thereby that applicants continued with their bending business with a full knowledge of the respondent authorities, inasmuch as the bending fees at the existing rate were accepted from the time to time as required. Then Mr. Chaudhary stated that although the said acceptance was with the complete knowledge of the respondents authorities in the release, but it was done pursuant to the interim order. Now kindly see the observation. We are unable to accept the said submissions for the reasons that all that the interim orders provided was that as long as applicants are required to pay the band fees, they would be paying it in the interim at the existing rate. But the interim order did not preclude the respondents authorities in any manner to act upon the discretion not to extend the licenses and also not to accept the band fees. All that the interim order provided was that the band fees should be accepted at the existing rate and not at all at the enhanced rate. Although a stand was taken by in the affidavit by the respondents review authorities that because of the pendency of the court proceedings, the licenses could not be renewed or extended. But the said stand would also be unacceptable inasmuch as there was no restraint order in any manner from the court during the proceeding, disentitling the respondent authorities from extending the licenses. Be that as it may, factual aspects that remains is that the applicants continue to pay the band rents at the existing rate and the respondents authorities continue to accept the same, leading to an equitable situation of there being an implied extension of the licenses. So as no proactive measures was taken not to allow the applicants to continue with the bending business. Another aspect of dismissal of WBC number such and such and the other writ petitions would be that all the applicants would now be required to pay their band fees at the enhanced rate. Mr. Majumdar, learned counsel for the applicant, candidly makes a categorical statement that all the applicants are agreeable to pay the band fees at the enhanced rate for the entire period, and for the purpose are ready and agreeable to pay the differences between the enhanced rate and the existing rate, which they have already paid. If the applicants pay all the arrear amount at the enhanced rate, being the difference between the enhanced rate and the existing rate, the situation as of today would be as if the applicants had never approached the court. There was no interim order, and they have readily agreed to pay the respondents the entire dues at the enhanced rate, and they have actually paid it. If that is the situation, we now leave it to the respondent authorities in the respondent release to take their decision as to what they would have done had the applicants paid their band fees for the entire period at the enhanced rate without raising any dispute. And accordingly, we also leave it to the discretion to do the needful as they would have done otherwise. In doing so, the appellants be also given an opportunity of hearing to arrive at any effective reasonable decision between the parties. Till any such respondent decision is arrived at, the appellants be allowed to continue with the pending business, but with a clarification that payments of bent fees would be at applicable NS rate for the interim period 16. All other terms of the judgment such and such shall remain is provided therein, except for modification such and such. In view of the above, without reckoning such and such, that's the judgment. Now, Lordship, kindly see. Basically, all the orders, judgments are passed on a fact of each case, my lord. Here, the fact is from the totally opposite, my lord. In my case, it's totally opposite. Here, it is the bending fees. That is the issue. There is the
You
fees.
see, out here there's the vending fees too, but the thing is that the observations of the court with regard to the whether the 2017 it did not say the 2017 catering policy could not be acted upon. It does not say that.
Yes.
The issue herein was only with regard to whether the fees should be paid at the higher rate or the lower rate.
Lower rate, that's the issue.
And so that was the issue. But then the division bench, keeping in view the 2017 catering policy, has not interfered with the 2017 policy at all.
That's true. But my summation, I want to say is here, my lord. There are two orders now. One is by Honorable Justice Barua, Honorable Justice Mehta. What happened?
No.
I'm coming to it. There are two aspects. The other day, on 27th, today is 31st. Today is 31st, 27th, 2 days back. Now, those judgments of the apex court and the railway board decisions, circulars I have read just a little while ago, my lord, that existed status quo as on today, 19 and 22, that orders I have read, my lord. That orders are not motivated by the railway board, my lord. Those things were raised before the single judge or not, that is not clear from the judgment, my lord. So my humble submission, my lord, I cannot compare the lordships, my lord. My humble submission is, my lord. Lordship may take up the other matter also. The other similar matter. Lordship may take up those matters, my lord. He may decide the matter. Because there is one single judge, my lord, pass the order, my lord, exactly the identical fact. So, but the other one is the fact is
No, you see, the other judgment is not a judgment, it's just an interim order part.
That's true, that's true.
Just status quo order was passed.
Yes, but in that small order, the big thing has been written about the apex court judgment.
No, but the apex court judgment, if you read it carefully,
Yes.
it was only with regard to companies, HUF, cooperative societies.
Yes.
Their powers to have their license renewed for 1 vends or 2 vends. And it was with regard to a situation prior to the 2017 catering policy coming into play. And the subsequent order passed in 2018 was a clarification of that order made in 2016.
Yes.
And the 2016-2017 catering policy was not an issue.
But the persons, the units which are existing before 2017, those are the persons still selling tea.
You see, those persons who have been given their vends as per the 2000 catering policy and whose term has not expired will continue to have their vends as per the 2017 policy. However, that provision for extension now is done away with.
But
That is
in
the
the
only
first
difference.
judgment, in the first of 2016 judgment, Lordship will find definitely 2017 was not there, 16 was there. In 16 judgment, it speaks about 2010 policy, and that was carried forward into the 18 judgment, and they are continuing.
Or carried forward only to the extent that they would finish off their term prior to extension.
Let us.
No, let us.
Yeah, I got it. But I want to say that Lordship is absolutely right. But I want to say, see the railway board circular, my lord, railway board chair circular. What circular? They've clarified, my lord. If all over India, one particular policy is going on, my lord,
only one
let them
thing.
get a clarification, my lord. That government circular. Railway
There
board
is
given
only
a-
one thing. There is only one thing. The circulars that he is relying upon, the railway circulars, it appears to indicate that
It's in relation to the judgment given by the Supreme Court so far as the catering policy of 2010 is concerned.
okay. It's not with regard to
It's not this. And even if I take this submission lordship, he gets 5 years from the 2017, it's already over.
My lord, please come to please 230. There's a clarification by the board. Please 238. Please come. Let us see. This is the last argument, my lord. If it clicks, otherwise no.
238.
238.
I've got it.
Yes, kindly see, my lord. This is my last trump card, my lord. This is my railway board, my lord. Kindly see, this is dated 13th/12/2021.
Yes.
Principal commercial managers, Northeastern Railways, Western, all the railways in India. Subject implementation of the High Court's order, and this, my lord, board letter dated. Clarification have been sought by Junior Railway regarding implementation of the board's letter of event number such and such. The matter has been examined in board's office in consultation with the legal something, my lord, and clarified that with a question. Left side issue whether existing lessees of individual provident fund can be renewed or not. If the existing minor catering units, that is like me, allotted prior to catering policy 17 under purview of renewal as per Supreme Court judgment are to be governed in terms of board dated even number dated 27/8/19. That is in page 232. I read, my lord. Let us see page 232. Let us see. This is what answer they have answered in a very clear language, my lord. It's explicit from this order, my lord. Now let us see page 232. 27/8/19. This is reference to board's instruction. Status quo in respect of minor static catering units. No, my lord, existed on 31/10/19. Since the decision of the review petition railway against.
Where are you reading?
You read it, my lord.
Page
232.
222.
232.
232.
That is dated 27/8/19.
Yes, yes.
I referred earlier, my lord. Also.
Yes.
Kindly see. This is reference to the board's instruction issued regarding maintaining status quo in respect of minor static catering units like me. Existed on 31/3/19. I was existing. Since the decision of the review petition by railway against judgment of the Apex Supreme Court was awaited, now by order dated such and such, Honorable Supreme Court has dismissed the review petition number such and such in the matter of such and such. Thus, Junior Railways are advised to ensure compliance of Honorable Supreme Court's order in the subject case and take necessary action as per extant guidelines to renew all the licenses held by the such and such. This
held by cooperative societies,
exactly.
partnership firms, and
I'm reading next para. Next para.
Last paragraph of the
Next
Supreme
para.
Court decision 2016, which
Next
was
para.
taken in review. All right.
Next
Now,
para,
for
next
a
para.
moment,
Let me read.
if my learned friend will permit, he has referred to the document at page 238. If you
No, let us see the next para, my lord. Let us finish reading this para.
Let me finish.
Let us finish. Yes, then he will start it.
All right.
However, last para. However, status quo in respect of all other minor static catering units as advised by board's letter dated 21/5/19. That's in page number 30. I read. Will continue till further orders and will be subject to the order of the Honorable Delhi High Court, such and such, Honorable Supreme Court, such and such. Contempt. This is what it clearly says. What happened to those cases? Finally, see. Status quo till today. Even last page I have read, my lord, 241, dated 10/8/22. Last year, August month's letter, my lord, specifically says what I have read just now, my lord. Advised to ensure compliance with the Supreme Court order, take necessary action, my lord. That's what, my lord. It's very specific. In all over India, on particular policy, in Guwahati, there is a separate policy. That's what, my lord. Let them have instruction from the railway board, my lord.
No, I do not need any instruction, Lordship. I will answer him right now. I'll answer him right now. Lordship will note the policy 2017 came in February or so, 2017. This particular document he is referring to at page 232 is of 2019. Now, Lordship has taken note of the conditions in the 2017 rules that those who are continuing will continue, and it will be till the end of their term. Now, for a moment, let us come to page 238, which my learned friend was referring to. I'll take your lordship to the very same column which he was reading. A few words have been left out. Page 238 remarks.
Yes.
Existing minor so and so allotted prior to catering policy and under the purview of renewal as per Supreme Court judgments are to be governed in terms of the board's commercial circular 22 of 17. This commercial circular 22 of 17 is the new catering rules. Under the new catering rules, had they been in possession, it would have continued. Even let us assume January 2017, he was there. Now we are in 23. It's already over, Lordship. This submission of my learned friend does not help him. Let him participate, Lordship. It's not a license in perpetuity, Lordship. There has to be competition, there has to be new phases, and only then the standard of service in the railways will improve. And Lordship has seen the division bench order. It has not in any way interfered with the policy of 2017, Lordship.
Okay. So we'll take a lot of time, Lordship.
Huh?
We have taken a lot of Lordship's time.
No, it's okay. At
Yeah,
least,
Only one last one, page number 2.
Lordship is taking too many
240.
concessions.
240.
yeah,
Page.
240.
40. One example I want to show. Of 2022.
Yeah.
South Central Railway.
Yes.
This office has examined the above referred letter and it is informed you that this office dated such and such had already communicated to the divisions clarified issued by Railway Board with regard to the implementation of the Railway Board letter dated 27/8/19. Repeatedly this one comes, that page 232 I read just now, my lord. It is once again reiterated to follow the guidelines issued by Railway Board such and such. 27/8 again, my lord. If this is being followed,
Lordship, now we are in 23. This would refer to those people who were there, and by now their term is over. This is
no, yeah, it is over. It's only omnibus
That-
statement.
no, it's for 5 years, Lordship. Lordship has seen that.
When did the catering policy of 2017 come into effect?
Lordship, that is
22.
27 to
27 to
70.
27 to.
February, 22nd February.
Then by the time this page 240 had come into play, that was already gone. 5 years had gone.
Lordship, perhaps
But still they are
regularization.
continuing.
Because that is not,
Anyway, the problem is, Mr. Council, one thing is you have not challenged the 2017
Policy.
policy.
No, that told them policy because of the clause there. My lord.
the clause is.
170.
Now, what do you say to the division bench not interfering with the order of the single bench?
They have division bench referred the matter, my lord, to the discussion. However, these people they have not been, my lord, vacated. They're still there.
No, that is another matter. That we are not going to say anything. What I'm saying is that the single bench order has not been disturbed by the division bench.
Para 15, if we come there, the appearance be given opportunity of hearing at any till such reason decision is arrived that the appearance allowed to continue with bending business. But with the clarification that payment of bending fees would be at the applicable NS rate. In other words, my lord, in other words, what happens? If this is accepted, their bending fees is, my lord, they will get the extension, my lord. It is the discussion. They have not said as of today, we have rejected that, my
We
lord.
have already.
That is still
we have
open, my lord.
already removed them from Rangia, Lordship. The process of removal is on.
And in my lord, Ernakulam High Court, Bombay High Court, they have beyond the order. And the bending fees, my lord, this they have taken today from us.
If he
This is the
refers to
receipt.
Bombay High Court, Lordship, I will refer to 3 other High Court's decision which has upheld the policy of 2017, Lordship.
This is my, they have taken the money today from me. This is the receipt.
No, you see, legally, I don't find much case in this and the petitioner thing. Only thing is that the circulars, yes, the circulars and the letters issued by you appear to indicate that the 17 policy is not being acted upon strictly.
It's been,
Anyway,
it's been.
no.
Yes, sir. Yes. I leave to Lordship, my lord.
You have done your job.
Done my job, yes, my lord.
And very
That's
quick-
our job only.
Quick time, Lordship. Yesterday engaged, today he's in. full force.
Yes, he's ready.
My quota is over.
Heard Mr. M. Nath, Leonard Senior Counsel, assisted by Ms. B. Chowdhury, Leonard Counsel for the petitioners. Also heard Mr. R. K. D. Chowdhury, Deputy SGI. For all the respondents.
Lordship.
Okay. The grievance of the petitioners is that They have been requested to vacate their catering stalls. White communication dated 2/3/2023, issued by the respondent number 5. On the ground that their license had expired. Next para. The learned senior counsel for the petitioner submits that a reading of clause 16.1.3 of the catering policy of 2010 read with the judgment of the apex court in civil appeal number 618-620/2016 bracket senior divisional commercial manager and others versus SCR caterers, dry fruits, fruit juice stalls, welfare association and another. And the order dated 30/10/2018 passed in Vendors Cooperative Society Limited and others versus Union of India and others bracket WPC number 373/2017 shows that the renewal of the petitioner's catering stall licenses can be done in terms of the catering policy of catering policy, 2010. Full stop. He submits that the only the full stop. Full stop. The learned senior counsel for the petitioners also submits that this court in its order dated 27/3/2023 passed in WPC 1719/2023 and in similar circumstances issued a direction for maintaining status quo. He also submits that a perusal of the letter dated 13/12/2021 and 27/8/2019 issued by the Ministry of Railways, Government, Ministry of Railways, bracket Railway Board, Government of India, would go to show that renewal of catering stalls could continue to be done in terms of the catering policy of 2010. Till a decision was taken by the Delhi High Court in WPC 13809/2018. And various decisions of the and various cases before the apex court. That's all. Anything else? Anything else? Next. What's that? He accordingly submits that the petitioner should be allowed to have their catering, the license for running the catering stalls renewed in terms of the catering policy 2010. Full stop. Next paragraph. Mr. R.K.D. Chowdhury, the London Deputy SGI. Anything for you to say? You are assisting, yeah, SGI. Submits that. The catering policy of 2017, which came into effect from 27 to 2017.
Lordship, just one line note made that single judge interim order that will be referred to only. That Justice made his order. That I referred to my lord. That one line will be added.
I'll refer it to it when I start. It does not provide for renewal of license of catering stalls. So he submits that as the catering policy of 2017 has superseded the catering policy of 2010, the provisions of the catering policy of 2017, which has not been put to challenge in this writ petition.
Not 7. From 2017.
2017, which has not been put to challenge in this writ petition, has to be followed. Full stop. That's all, I think. Full stop. That's right. He also submits that in terms of clause 20.2 of the catering policy 2017, tenders that had been finalized and letter of award (LOA) issued prior to the coming into force of the catering policy 2017 would still be valid and will still be valid for the period of the license, subject to no further extensions being given, as the extension would have to be given, as extension cannot be given under the catering policy 2017. He also submits that the present case is a covered case in terms of the orders passed by this court in WPC number 5143/2014 and (5313/2017). I have heard the learned counsels for the parties. Clause 16.1.3 of the catering policy of 2010 provides that the term of a catering stall/vend shall be for a period of 5 years, and extension can be given after every 3 years thereafter. In the case of senior divisional commercial manager and others versus SCR caterers, dry fruits, fruit juice stalls, welfare association and another, which was decided on (29/1/2016), wherein the apex court had held that as per the provisions of the Catering Policy 2010, the action of the railways in not granting renewal of license to members of the welfare association was arbitrary and unreasonable. Full stop. The apex court in its order dated 30/10/2018 passed in Vendors Cooperative Society Limited and others versus Union of India and others, bracket WPC 373 of 2017. Where is that order again?
My lord, that will be in page number 183.
Direction is at page 186.
Had clarified para 34 of the judgment and order dated 29/1/2016 passed in that dry fruit censor. Huh? The apex court thus held that the confusion caused by para 34 the apex court thus clarified section para 34 of the order of the earlier order by holding that cooperative societies, partnership firms, and HUF shall be entitled to renew all their licenses shall be entitled to renew all their should be entitled to renew more than one license if they had more than one license. Next paragraph. The above clarification made by the apex court in its order dated 30/10/2018 passed in WPC number 373 of 2017 makes it clear that the issue therein was not with regard to the catering policy of 2017, but with regard to the catering policy of 2010, which had been decided in the judgment and order dated 29/1/2016, passed in dry fruits. Next paragraph. Clause 20.2 of the catering policy of 2017
Page 177.
This is why it's good to dictate in your presence. I don't have got to keep on doing. Otherwise, it becomes a big headache for us later. Provides that tenders that have been finalized and LOA issued prior to the date of notification of the catering policy of 2017, shall be allowed to continue as per the policy guidelines prevailing at that time. Zonal railways will cancel all such tenders and return the earnest money to the tenderers in cases, where LOA has not been issued before issuance of the catering policy 2017. Clause 11.2 of the catering policy 2017 provides that the tenure of a food plaza shall be for a period of 9 years. Full stop. Tenure of all other catering units, bracket, major units and minor units, bracket closed, will be for a period of 5 years only. Full stop. There will be no further extension / renewal, except for units specifically referred to in para 3.8.1. This is page 173. 173, yeah. Para 3.8.1 of the catering policy of 2017 is with regard to base kitchens under the departmental operation of zonal railways in Nagpur, Chhatrapati Shivaji Terminus, Mumbai Central and Balharsha. Para 3.81.1 is not applicable to the case in hand, as the catering stalls that are sought to be renewed in this writ petition pertains to the Guwahati and Kamakhya railway station. Next paragraph. As can be seen from the provisions of the 2000 catering policy of 2017. There is no clause providing for extension of the tenure of catering units / stalls beyond 5 years.
Major and minor. Major and minor.
Okay, major and minor are same, so you, why
Because
is there a third thing?
because 3.8.1 also says about other stock category of stocks.
Mr. Council, 3.8.1, I've already clarified, it deals with only 4 stations. And Guwahati is not included in that station. Only 4 stations are included. Isn't it? Am I correct? Am I wrong?
Just
Just read it.
3.8. All kitchen units, next page 164, all kitchen units, that is refreshment room at A1 and A category stations.
Okay.
That's why I'm saying, my lord. So,
Uh-huh.
yes, kitchens out here would also be included probably, but these are the stalls held by the petitioners, these are not. based-
Okay.
That's why I said.
So in the
I'm
3.8.1, just add one thing also.
I'm sorry to interrupt.
All kitchen units in that 3.8.1, all kitchen units, that is refreshment rooms. That is refreshment rooms at A1 and A category stations would also be included. So, however, the petitioners catering stalls cannot be included under, would not come within the provision of para 3.8.1. And where are we? Come back to the main thing. Come back to the main. No,
As can be seen from the provision of catering policy 2017, there is no clause providing for extension of the tenure of catering units, public stalls beyond 5 years.
beyond 5 years. Just though no, full stop. The catering policy of catering policy 2017 provides that all licenses and letter of approval issued as per the catering policy of 2010 would be allowed to would be considered to be valid for 5 years, even under the catering policy of 2017. Sans any further extension being given to the same in terms of the catering policy of 2017. Full stop. Next paragraph. In the case of now in WPC 5313/2017 bracket NF Railway Vending and Catering Contractors Association Lumding Division versus the Union of India and 3 others, which was disposed of by judgment and order dated 24/1/2023. This court has held that in terms of the catering policy of 2017, the right to renew a license had been taken away and allotment of various vending units would be based upon open tender. This court has also held that the question of interfering with the catering policy of 2017 did not arise. full stop. In the case of, in WPC number 5143/2014, inverted commas, NF Railway Vending and Catering Contractors Association, Lumding Division, represented by its secretary versus the Union of India and two others, which was disposed of by order dated 24/1/2023. This court had held that the catering policy of 2017 does not have the concept of renewal of licenses. And under such circumstances, the court could not issue a writ to allow the members of the petitioner association to continue their business of vending, which would be contrary to the catering policy of 2017. This court thereafter gave liberty to the respondent railways to resort to such action as deemed fit in terms with the existing catering policy of 2017. The judgment and orders passed in WPC 5313 of 2017 and 5143 of 2014 were put to challenge by WA number 47 of 2023 and WA number 54 of 2023 respectively. The division bench of this court disposed of WA number 47 of 2023 and 54 of 2023 by a common judgment and order, by a common order, wherein it did not interfere with the decision of the learned single judge, wherein it held that, which had held that the catering policy of 2017 did not provide for renewal of licenses of catering vends / stalls. It also did not interfere with the direction passed by the learned single judge, wherein liberty had been given to the respondent railways to resort to such action as it deemed fit in terms with the catering policy of 2017. On considering all the above facts, this court is of the view that the catering policy of 2017 not having provided a provision for renewal of license of vending stalls / vends, the petitioners cannot have any legitimate right to have their vending stalls / vends extended. The license for the vending stalls is also extended beyond 5 years in terms of the catering policy of 2017. First one. In the view of this court, the status quo order passed in WPC 1719/2023. The interim order of status quo passed in so. The interim order of status quo passed in WPC so. Cannot be. I'll correct it. Anyway, in view of the reason said above, this court does not find any merit in the petition. The petition is accordingly dismissed.
Lordship, may I request my learned friend's name be included?
Mr. RKD Chaudhary, Deputy SGI, and
B. Sharma.
B. Sharma for the respondent.
It applies, my lord.
Item number 48.
Yes. Yes.
The petitioner is a contractor, my lord. He has been awarded the contract in respect of respondent number 3, my lord, for cleaning and my lord, the Jorhat Medical College. My lord. In terms of the agreement executed in 2021, it was for a period of 2 years. But in the said contract, my lord, it was indicated that the payment would be made by the government, my lord. Now, my lord, all of a sudden, my lord, the government has issued a notice under the DME saying that they don't have financial resources to make payment, and for any other for the next session, my lord, the hospitals have to make their own arrangements, my lord. Now, already, my lord, we have served, my lord. We had been doing our duties, and my lord, a amount of 5 crore 14 odd lakhs is still pending. And my lord, on 14.
Let us see your agreement. For how much is it?
Yes. August. My lord, will kindly come to page 20, my lord.
Yes. Agreement is made on 31 August, 31st August.
Yes,
And it is for a period of 2 years.
2 years, my lord.
And for what is the amount payable to you for the entire 2 years?
Well, it's monthly cleaning maintenance plots, 44 lakhs per month.
44 lakhs per month.
Yes, ma'am.
44 lakh 63,000.
Huh?
44 lakh 63,000.
And at
Page
page
21, my lord.
26, my lord, your lordship would see the total outstanding, lord. Page 26,
Not paid.
not paid.
Yes, what to do?
And lord, the issue is, my lord, I have indicated to the authority that I will not be continuing beyond 31st March, my lord.
Okay.
And my lord, I have been warned, my lord, that coercive action would be taken against me, my lord. So, my lord, I am praying that no coercive measures would be taken, my lord.
But can the agreement be terminated?
My lord, that is an issue, my lord. The situation is such, my lord, they don't pay, but I have to make payment to my laborers, employees and all.
That is
Lord.
the-
How I'll make the payment? And the lordship would kindly see.
Can it be on Tuesday, my lord? In fact, my lord, I have telephonically, my lord, the principal, who is the, my lord, person with under the agreement, he is informed that, my lord, now it is the hospital management society will make the payment. So he need not have to worry. We are bound by this contract, my lord. These are the
But you have not paid for such a long time.
No, it's not
5
true.
crores.
But that part also, my lord, in the letter, lordship may kindly have a look at page 47.
Yes.
It categorically states that, my lord, we have been submitting the bills to the DME, para 2.
No, that is okay. That is your internal problem. You
Yes,
see,
internal
your internal problem shouldn't be his problem.
Doctor.
The problem is he wants the money. He doesn't know if you are sending it to
No, I'm just not saying that.
this department or that
With regard
department.
to
That
I
is a
will have the
different issue.
instruction, but my lord,
All
in a
three are
medical
parties in
college-
this case, my lord.
Huh?
Government is party,
Yes.
DME is party, and the principal is also
So-
party.
I will come up with the inspection, but my lord, abruptly, my lord, he from tomorrow, adamantly, my lord, if he stops, my lord, it's not that, my lord, it can be replaced by, in one day. it can
Look,
be replaced by-
because if you stop, then how can you just
petition will
stop
suffer.
unless there is in the agreement, there is a clause for stopping?
Well, they are making alternative arrangements, my lord. Only thing that I am,
That part I have no instruction, my lord. I have a telephonic instruction that, my lord, he will continue, but they will make the arrangement.
But you make some payment, you have got to make some payment by Tuesday.
But
By Tuesday,
no, that-
today is 31st, year ending, one day left,
no, year ending will be today, itself, my lord.
correct?
Yes.
So make some payment.
That by Tuesday it will be difficult, but my lord.
No,
let me
no,
have the
you can
instruction.
make the payment today in check, you can give the actual payment on Tuesday.
No, that won't be possible, my lord, without the budget allocation. But let me have the instruction for 2-3 days, he can at least continue, my lord. Let me have the instruction.
I do not know. We are not going into whether you continue or don't
Yes,
continue. Why
yes.
should we go into that issue? That is between you two.
Lordship.
We are not on that. Today, we are only issue is that you have not been paid. So we will ask the question why you have not been paid.
So on Tuesday, my lord, I will have.
Otherwise, tomorrow you say High Court allowed us to leave the job unannounced.
no, I'm not
Or
asking
without
for lordship that we may be permitted to, so it's my.
So this case is only with regard to your non-payment of bills, that's all. Okay, right. Mr. R. Dubey, learned counsel for the petitioner, submits that in pursuance to an agreement dated 1/8/2021,
31 is.
31/8/2021 for mechanized cleaning of the college of what?
Jorhat Medical College and.
Of Jorhat Medical College and Hospital at the rate of rupees 44,
63.
63, 172 per month. The petitioner whose agreement is going to expire on 31/8/2023 has been doing his job diligently. However, the respondents have not been paying the petitioner his bills from March 2022, which has now amounted to 5,14,10,75. Mr. B. Roy, Senate counsel for the respondents, prays for accommodation for 3 days to enable him to obtain instructions. List the matter on Tuesday.
Well. I will-
This is accommodation, this is time.
With due respect,
Huh?
with due respect, I submit that my lord was pleased to file an additional affidavit in the matter.
Oh, yeah, filed it. When did you file it?
My lord, I filed a long time back. I made a mention in the morning 10:30 to bring it on records. It was not.
Okay, yes, because I had this file yesterday. I did not see this.
Today.
It was filed today. I mean, it came today.
Yes. My lord, with folded hand, my lord, I just beg pardon. There's a little mistake in
You make correction.
page 6, my lord. I have written because the assured career progression SCP and modified assured career progression MSCP can be treated as a substitute of profession. It should be cannot, my lord.
You too.
I'll just make a correction if my lord permits.
So what is to be done?
Well, yes, basically, yes, the next term, high courts order are different high courts. But the fact is remain, just after the YB Ranger's judgment is available. But there is no post of officer regarding his.
There's nothing left.
Nothing left, my lord.
And once he's been given his ACP.
After that,
But when are the 3 and 4 to be given the ACP
Well,
2024 and 26.
Yes. Petition number 3 will be on 24 and petition number 4 will be on 26. Others already got, but promotional post, yes, there is no scope of promotion at this stage because of the post is not there.
Madam, I beg to submit, my lord. DPC held in 2008.
But detail I have not gone through the.
There was no vacancy between 2002 to 7, my lord. Then in the said DPC appointing authority approved the DPC. They are to place the individual, my lord. Now the amendment of the rule took place in 2012, my lord. So 4 years they waited, my lord. And my lord, the ACP, Assured Career Progression, in 5th Pay Commission, and MSCP that is given on 10 years, modified Assured Career Progression with reference to 6th Pay Commission. My lord, it is to avoid stagnation. So promotion is the concept which is for the benefit of the, it is for the win-win
He
situation.
says
my
that
lord.
he has not read the affidavit. I have not read your affidavit
Yes, my
also.
lord. So my lord, my humble submission, my lord, 29th of June, my wife has to replace the knee. So my lord, 29 June will be convenient. My lord.
Okay, right.
I'm deeply
The affidavit, additional affidavit filed by the petitioner has been placed on record today. So as Mr. K.K. Parasar, CGC submits that he has not had time to go through the same, list the matter on 29/6/2023 on the pair of the petitioners council.
29 or 27?
29 June.
29.
My lord, this, may I correct the page number 6? I have to
You can correct. Yeah.
That is of Thursday, my lord. Deeply grateful, madam.
Malak, 29/6 is a holiday, Malak, maybe on 27/6, Malak.
29 is a holiday,
27, my lord.
27.
27.
May I please, Lordship? Lordship, I am appearing this case on behalf of my senior, Mr. S. Samaria. Lordship.
Item?
Item 26 to 30, Lordship.
Yes.
Lordship, on last that, the respondent has given last chance to file counter affidavit. Lordship, that they didn't still file a counter affidavit.
Yes.
There are 5 matters in total, madam. In 2 of them, we filed our affidavits. With regard to 3, our affidavits are due, madam, and I also have updated instructions on those 3 matters.
Lordship, on last occasion, they are given final chance, Lordship.
Okay, you argue. Argue.
Lordship, my
Yes.
senior will argue on this case.
Madam, they express urgency, madam. They mention the matter and when the fact.
I'm ready. Two cases they have filed affidavit.
Yes,
So
Lordship.
come, you're ready. You're in a hurry. We'll do it.
Lordship, immediately after.
Call him. Call your senior.
No, he left the court due to some.
Then don't press just for drama's sake. Don't do that.
Okay,
They
Lordship,
could have informed us in the morning, madam.
matter may be fixed immediately after.
We can do the ones he has, they have filed the counter affidavit, we can do it, not a problem. Anyway, you tell me, when can you file?
I will file it within 3 weeks, madam.
3 weeks, why 3
2
weeks?
weeks, madam. Let the matter come up after.
You have got you have said updated instructions are
Updated
there.
Instructions, madam. I have.
Tell me in which cases have you filed your counter?
The first 2 items, madam.
First two means 833 and 987.
Yes, madam. In those 2 writ petitions, we filed that.
Are you sure?
Yes, madam.
Okay, right. Mr.
MM Zaman Lord.
Huh?
MM Zaman Lord.
M,
MM Zaman.
not here.
Yes, Lordship, I am appearing on behalf of Mr. S. Samaria.
Mr. M. Sensor appears on behalf of Mr. S. Chamaria, Learned Counsel for the petitioner. Mr. P. Chaudhary appears for the
PHE department.
PG department and submits that affidavit in opposition has been filed in WPC 833 and WPC 987. Acha, 833/2020 and 987/2021. So he submits that he will be filing affidavit in opposition in the other three writ petition within 2 weeks, comma, as he has received updated instructions for the other three cases. This is the matter after the Bihu vacation.
Okay. GP of record.
May I please, Your Lordship? May I please, Your Lordship? In this case, leading and advocate T.J. Mohanta's father has expired, so 2 weeks can be granted.
Whose father has expired?
T.J. Mohanta, leading advocate.
This particular matter, nothing survives the writ petition. Whatever the grievances they have sought for, that has already been, they got the relief. Their whole case, there were three.
Violation of
There were
construction.
three ABC, three particular apartment, ABC. Now, in respect of ABC, my lord, the respondent number 10, who is the developer, he had an agreement with the owner that he will construct A and B. A and B is completed. Now, C has been constructed by the owner. Now, he states he is one who has purchased a flat in so far as A is concerned, block A is concerned. So now they made a complaint that there is some violation before the GMC. Violation of there is a violation. There is a 7th floor which has been constructed and that has been given to me. And C block, that has been, there is an agreement as a tenant where I am converting the residential to a commercial complex. Now that has been taken care of. It has been sealed. It has been sealed. I cannot run it. There is an order passed by this court. And there is a so cause which is issued by the GMC and GMDA, where a reply I have to file it.
You are for the petitioner.
No, he is for the petitioner. I am for the response number 7 and 8. Where, my lord, I was running a hotel in that C, block C, then it has been sealed. Court said that you seal that, you cannot do it. And that has been, it was residential, permission was given. It was.
But what is his grievance?
His grievance is that you seal that. How can he do it? He is one of the occupier insofar as flat A is concerned. And his grievance, illegally some construction has taken place in flat A, and in C block, it has been permission was granted as a residential complex. How can it be converted to commercial you running a hotel? So his all grievances have been met out, my lord. What remains in this case?
My lord, let the matter become after 2 weeks. My lord, my senior will argue the case.
Okay, right. A general prayer has been made on behalf of Mr. T.J. Manta, whose father has expired. Full stop. On the other hand, Mr. D. Das, Leonard Senior Counsel, appearing for the respondent number 7, submits
7 and 8.
7 and 8, submits that that nothing survives in the writ petition, as the grievance of the petitioner has been met
Yes,
by the sealing of the apartment.
yes.
Full stop. List the matter. When?
After 2 weeks, after Bihu, my lord.
This is the matter after Bihu.
My lord.
Obliged.
Deputy.
May I please, matter relates to transmission line compensation. Kindly may parents the last order.
Yes.
Yes, Lordship, on the last occasion, Lordship wanted to know the reason as to why this checks which has been issued in favor of the petitioner has been returned back. So I have got the specific instruction from the circle office. So here it says that along with 2 other persons, the checks has been returned. Here is a serious public complaint against the petitioner. So the petitioner has previously been called before the circle officer and the SDO to appear in person. And from what he has deposed and he has admitted is that he has been taking a bribe from other beneficiaries who are to get the compensation, that if at all you want an escalated compensation amount, then some amounts of around 5,800
from someone 15,000, someone 18,000, such amounts has been collected by the petitioner. And accordingly, he says that if at all you wanted an enhanced compensation amount, this amount has to be paid. So that thing the petitioner has admitted before the circle office. And finally, what has happened, he has also deposed, that deposition is here. He has deposed that, yes, I have taken all those amounts and this complaint was lost. And that apart, there is another complaint which is being lodged before the circle office by another two persons, saying that in some cases, compensation amount has been received by one person thrice, and the petitioner has received his share of compensation, whereas the genuine persons who ought to have received, the petitioner is only the landholder of 15 lessa of land, and for which he has been paid this amount of 1,96,452, and this check has been returned back by the circle.
Yes, why has it been returned?
There is a complaint against the petition because
With regard to what?
complaint, he is not entitled to that amount.
Why?
Because from the last
He
month,
is not the landowner.
no, from the last month's report, it appears that the petitioner nor his father is in possession of over that particular plot of
His
land.
He?
Petitioner and his father, petitioner is Muslim Ali, and it is with regard to Dag number 7 of Deotari and the Manipur Revenue Circle. So I have the copies of my set of instructions, in fact. So here it comes out clear that the petitioner is not in possession over Dag 7 or that particular plot of land.
But
He is not in possession and
whether it is in his name,
No.
whether it is his,
No,
no, not in.
that has been denied. That apart, there are public complaints against him for illegally collecting money from different beneficiaries.
Okay.
So in fact, in this respect, I have received a detailed instruction. I need to file my affidavit
Okay.
of service.
Mr. S. Barwa appearing for the learned, for the respondents number 6 and 7
Yes.
submits that the check was returned as the petitioner was not in possession of Dag number
7.
7.
Yes.
For which the check had been issued.
That apart, there are public complaints
So
against.
from that apart, there were public complaints against the petitioner.
Hmm.
So he accordingly prays for 3 weeks' time,
That's a 4 week.
4 weeks' time to file affidavit in opposition. This is the matter after 4 weeks.
That is your lordship. My lord, in view to 27/1/22, there is an order, my lord. The citizen sought time for filing affidavit in opposition, my lord. But she is very much available, when she is supposed to appear, my lord.
Huh?
A Gayan, my lord, MS A Gayan. Asile.
Where is she? Gone home.
I would like to call her.
Next.
Then lordship,
What to do?
my lord, give her 2 weeks time further, my lord.
Okay, right. Ms. Gayan, level CGC granted a further 3 weeks' time to file affidavit in opposition. This is the matter after 3 weeks.
Deeply blessed. My lord, one more submission, my lord. Can it be a fixed date fixed, my lord? Otherwise, my lord, it will remain any date after.
22 matter. Next. We have given you 3 weeks' time to file affidavit.
Yes, well, that is sent for taking,
Huh?
sent for taking.
Okay, send for me.
May please. Lordship, I am leading by senior counsel Mr. Sahiwala because of his personal inconvenience, my lord, he had to leave. Only my lord for slight accommodation for the day.
My lord, it is my acquisition compensation is pending because the government granted 98 lakhs and others. In view of the order passed in the petition, the acquisition compensation has been stayed.
What to do?
Immediately after the vacation.
Adjournment prayer has been made on behalf of Mr. G. N. Sahiwala, Learned Senior Counsel. Accordingly, this matter on when do you want? When do you want?
It will be any date after the vacation.
This is the matter on 25 4.
My lord, it may be fixed on 27.
27 4.
May I please, my lord, in this matter, respondent number 1 and respondent number 9 are to file their affidavit in opposition.
Who are to file? 5 and 9.
No, my lord, 1 and 9.
1 and 9 have filed.
No.
Not filed.
Not filed, my lord.
Yes, you are for
I for the restaurant land, Lordship.
9.
9.
When are you filing?
1 week. Lordship.
Tomorrow.
Uh,
Very good.
1 week.
Huh?
1 week. Lordship.
1 week. And what about you?
My lord, I have clear instruction, my lord. Perhaps we are not required to file affidavit, my lord.
Okay.
Lord, we have given settlement with the petitioner, my lord. And in
So you are not filing.
17, my lord.
Huh?
Page 17, my lord, annexure 1.
Yes.
It is expressly written, my lord.
Yes.
Yes,
3rd September 23.
Para 1, my lord.
So after 23. So let him file.
My lord.
Let the respondent number 9 file.
Yes.
Hai na? Is it required?
No, if they want to file,
Huh?
then if they want to file, then 1 week time may be allowed to them.
Okay, right. Mr. S.R. Rabha, Learned Counsel for the
Respondent number 1, 2, 3, 1 to 3. And 5, my lord.
1 to 3 and 5. Submit that he will not be filing any affidavit. On the other hand, Mr. R. Sarkar, appearing for his point number 9, submits that he will be filing affidavit within
1 week.
1 week. Mr. S. Barwa, appearing for respondent numbers
4.
only 4. For point number 4, submits that he will not be filing any affidavit. Correct? Are you filing anything?
Not sure at the moment because I haven't got anything.
Okay, just say appears for respondent number 4. And list the matter after a week.
Deeply obliged.
Maybe the matter non-payment of the contractor's bill, Lordship. Also, similar matter already disposed of by coordinate plans. Lordship, I have the instructions. Lordship.
Yes, whether it is admitted or not.
Lordship, I have the instructions. Lordship, Lordship, it is in, I have the instruction from the executive engineer. There are minor differences with the amount. Overall, the
If the government issue necessary sealing, what is it?
Lordship, necessary, Lordship,
Necessary what? Sealing. It says sealing, etc.
necessary fund maybe.
No, it says sealing.
Yes.
Necessary fund, what do you mean? if the government issue necessary ceiling to pay the dues. Orders must be.
For the fund, we have to need the finance approval also.
Okay, right. Heard Mr. N.J. Gogoi, learned counsel for the petitioner, and Mr. S.M. Hassan, learned standing counsel, PhD. Pusta. The petitioner is a registered class 3 contractor under the Public Health Engineering Department, Jorhat Division, Government of Assam. On completion of several works regarding installation of a ring well fitted with SHP, including construction of platform, drain, soak pit, etc. in Anganwadi centers under NRDWP for the year 2012-13 under Jorhat (PHE) division in the Jorhat block in the Gaon Panchayat, Pachim Thengal and Modhaya Thengal respectively. My God, all this is. No, just right. The petitioner is a registered class 3 contractor under the Public Health Engineering Department, Jorhat Division, Government of Assam. On completion of several works under the Jorhat PHE division for the year 2012-13 and 2014-15. The petitioner submitted his bills for payment of his contract works. Though part payment of his contract bills were made by the PHE department, rupees 3,99,627 are still lying outstanding with the PHE department. He accordingly praised, the petitions council accordingly praised that a direction should be issued to the respondents to make payment of the outstanding bill amount. Next paragraph. Mr. S.M. Hassan, learned standing counsel PhD, submits that he has received parawise comments from the respondent number 4, wherein it has been stated that due to paucity of funds, part payments of the petitioner's bills had been done. Full stop. Further, as per the record, an amount of rupees 3,68,897 was still lying outstanding, was the outstanding bill of the petitioner. It also stated that as and when government issued necessary orders, the bills would be paid. Full stop. Next paragraph. In view of the parawise comments, which have a copy of which has been submitted to this court, it is clear that the state respondents have admitted that they still owe an amount of rupees 3,68,897 to the petitioner. Though the said amount, though the admitted amount is less than the amount claimed by the petitioner by about 31,000. Rupees 31,000, by about 31,000. Be that as it may, as the state respondents have admitted that they are liable to pay the petitioner rupees 3,68,897. The respondent number
Number one.
Huh? The respondents, the respondent numbers 1 to 4.
Respondent number 1, 3, 4, 5, and
Well, no, not all of them. The respondents, all the respondents are directed to ensure. Huh?
Lordship, respondent number 2 is finance.
It's very important. That rule, he's the one who says to give approval.
Also, direction may be given to the civil engineer.
Huh?
Respondent number 3 is engineer.
All will give to all. All the respondents are directed to ensure that the admitted amount of rupees 3,68,897 is paid to the petitioner within a period of 2 months from the date of receipt of a certified copy of this order. Acha, before that you write Mr. H. Aliha appears for respondent number 2.
Lordship, can it be?
And Mr. S. Barua appears for?
Not there.
Not there.
Government is not. Lordship, can it be like this? Respondent number 3 will verify and pay as per.
Okay, full stop. You have already, this is your Sarawai's comment.
Lordship, as per Tamsher Lordship, the chief has to verify it.
Full stop.
Give the admission.
So what, just read that.
Be that as it may, as the state respondents have admitted they are liable to pay the petitioner rupees so and so, all the respondents are directed to ensure that the admitted amount of rupees so and so is paid to the petitioner within a period of 2 months from the date of receipt of a certified copy of this order.
After necessary.
Stop. However, by way of abundant caution, the respondent number
3, Lordship.
3 shall make a verification of the petitioners, shall make a verification of the outstanding liability to be paid to the petitioner within a period of 2 weeks from the date of receipt of the certified copy of this order. The parawise comments are made a part of the record and marked as Annexure X. Then, next.
Next attempt is same. 37 also same. Only.
But anything.
The amount is.
Okay, out here you write. Out here, same thing, huh? But contract works for the period 2012-13, 2014-15. Then the amount claimed by the petitioner is 3,80,420. And the admitted amount is 3,75,912. So the difference is around 4.4. For around 4,400. 4,400 difference. Everything else the same. Disposed of. So this will be also an Annexure X. I'll give this.
May I do your lordship?
Yes.
As per my instructions, which I have received from the petitioner lordship, they have received the gratuity amount, provident fund amount, and salary amount.
Oh, very good.
But the leave encashment and LIC amount is still left out. They have not received.
Lordship, LIC amount is not in existence because the gratuity that was in place with the LIC authority that has been given. And Lordship, with regard to the monthly pension, only petitioner can say because there has been no communication with us from the Provident Fund Commissioner's office. And Lordship, LEB Lordship, my instruction, telephonic instruction, Lordship, LEB in his case, Lordship, it will not be leave encashment benefit. Lordship, in his case situation, Lordship will have to decide because we have filed a review because at that time Lordship has passed the order. The also Brahmaputra hotel was not in existence. Lord.
At least you've got some money now
Yes,
at the end,
definitely.
after a long time.
Yes, Lordship, because of your Lordship intervention.
No, because of you fighting so hard. Little bit he's got at least at the end of the day. So he has been given,
Lordship, he has received the amount of this one, gratuity amount,
gratuity,
provident fund.
provident
Lordship,
fund.
gratuity amount is 1,32,870.
No, I don't want the amount,
Yes, sir. And the salary amount,
salary.
Yeah.
So he has not been given
leave encashment and LIC.
leave encashment and LIC.
LIC.
Okay, so according to you, he's not entitled to LIC
Yes, Lordship.
because he has been given gratuity.
Yes, Lordship.
And leave encashment,
Leave encashment, Lordship, my instruction is that that also he is not entitled, subject to Lordship decides.
in the review.
Yes, Lordship.
Since they have provided the provident fund amount.
Huh?
Provident fund amount has already been given. So I think the petitioner is entitled for leave encashment, but I am also not sure. Let me have the instruction because.
Yes. No. So anyway, so at least, right.
Okay.
Heard Mr. R.M. Das and Mr. B. Chaudhary. Mr. R.M. Das submits that the petitioner has received gratuity, provident fund and salary.
Okay.
However, he has not been given leave encashment and LIC. Next para, Mr. B. Chaudhary submits that the petitioner is not entitled to receive LIC as he has already been given gratuity. He however submits that the question of whether the petitioner is entitled to leave encashment would depend upon the decision to be taken in the review petition. Accordingly, Kamal, is this matter when?
After Bihu.
This is the matter after BU. To enable the council for the parties to obtain instructions.
Okay.
So we'll decide the review after that.
Copy of the review petition has not been filed.
Yes.
Lordship, in this matter, I am appearing for 1 and 2, Lordship, and new incumbent has been implemented already, Lordship. So, Lordship, I am likely to get the wakalatnama from his behalf.
You're likely to?
Get the wakalatnama, Lordship.
Wakalatnama.
Yes, Lordship, that is not yet final.
More than that, what about complying with the order?
Lordship, in the meantime, Lordship, BTC authority has done an audit, Lordship. In the court's order also, it was mentioned, Lordship, in some other cases, Lordship. That is already completed, Lordship. In the meantime, Lordship, after filing this, Wakalatnama, Lordship, will file our affidavit.
Let him take some instruction on the next date and file an
Yes.
affidavit.
Lordship, some other case also, when in today also, Lordship, in court number 12, item number 41 to 44, Lordship, therein also some order was passed, Lordship. So all these matters may come together, Lordship.
Are you the last lawyer still wearing a mask in Guwahati?
No, it has increasing trend.
No, that is okay. But other lawyers wearing?
Yes.
They started again.
So many, Lordship.
Another one.
Lordship, yesterday
And-
14%.
Huh?
K Gogoi.
Hey, oh, I thought you were the last, the Lone Ranger.
We'll
Okay.
start again, Lordship.
I
Yesterday-
think now again we have to join the.
Oh, then there is one lady in the back also. She's wearing also. Okay.
Lordship,
I found
the
so many.
order was passed on 8/4/2021. Already 2 years has gone.
Yes.
So my lord, the petitioner,
We'll give a short date.
Lordship will take up this matter after 2 weeks, Lordship. In the meantime,
Mr. P. Nayak, Learned Counsel, appearing for the respondent number
In the present lordship 1 and 2.
1,
1 and 2.
1 and 2. Submits that he will obtain instructions and file his wakalatnama in the meantime.
Like it. Probably.
File his wakalat in the meantime. List the matter on
18th of
No, lordship may not fix a date, lordship, because in the other cases also no date has been fixed.
no, where to fix a date.
April.
List the matter on
19th,
26.
yes, my lord.
26.
Or 28 lords, 20.
Why?
If possible, lordship, in the meantime, I'll file my affidavit.
Yes, list the matter on 26. It's okay. 26. Next,
Apply.
26.
Yes. Same, my lord, and matter may be
40, 41, 42, same.
same, my lord.
But who is appearing for the,
P Nayak also. He has left the court, my lord. And he
okay,
will
okay.
appear all for all the cases because the petitioner is same, my lord. So the
No,
work on-
petitioner might be same. The respondents are the same or not?
Same.
Okay, I do not know. Okay, maybe he thought,
No, my lord, on other matter who is listing for.
okay, you put the same order there.
And court number 12 also.
Put the
same.
same order, huh?
Same.
40,
42
40,
and 42.
41, 42. Next.
May it please your lordship, I filed for impleadment of the legal heir, that is the wife of the petitioner. Petitioner was died in the year 2019, lordship. And now she is a resident of Jammu and Kashmir. Now she filed this petition for impleadment on.
Who is for the other side? Mr. Barua? Any objection?
Without the brief, but from the name, I could make out J. Roy is there. J. Roy, but just couple of, or maybe hours back, he collapsed in the corridor.
I heard in the, just before lunch or something.
Yes, there was a commotion here. So he has been immediately shifted off to international hospital. And that's why maybe no one is repenting at the moment. So let it be fixed for some other day.
J. Roy is for 7, 8, 9. No, how do you see the petitioner has died? Correct.
Petitioner died.
And now the wife wants to be pleaded. How does it matter?
That hardly, yes, lordship will go.
Right, heard Miss
And Chaudhary. And Chaudhary.
N. Chowdhury, learned counsel for the applicant, who submits that the applicant, namely, what is her name?
Interpol Court.
Inderpal Kaur, wife of late Gurmeet Singh, resident of Bhore camp under Satwari police station, Jammu and Kashmir, should be impleaded as the writ petitioner and allowed to substitute her deceased husband,
Yes, sir.
who was the petitioner. Mr. S. Barwa appears for the state government and submits that he has got no objection to the same. Accordingly, Ms. So-and-so, Interpol, is impleaded and is allowed to substitute her deceased husband as the writ petitioner. Let us see to make the necessary correction to the cause title. I is accordingly disposed of. Now you give me the main case, right? In view of the order dated 31/3/2023 passed in IAC 508/2022. So-and-so is impleaded as respondent number 1, writ petitioner number. So-and-so is impleaded and allowed to substitute her deceased husband as the writ petitioner. Then what do we do? List the matter? List the matter after 2 weeks.
May it please your lordship. This matter is relating to release of transport subsidy, my lord.
But I have filed an amendment petition because the particular notification I have not challenged. Which my lord, my period of claim is of prior to that notification.
Then,
Honorable court suggested my lord.
but your period of claim is prior to the,
Notification.
huh?
Notification means my lord, some amended notification, my lord. On notification, my lord, that circular. That my lord.
What is to
intends
be done?
because So many
They
amendment
file an
petition
IA.
may be allowed.
Huh?
They file an IA.
You want to file
No,
objection?
not us.
Do you want to file objection or what?
No, we don't have any objection regarding the IA.
Okay.
So petition may be allowed and I may be allowed to file a consolidated petition. That I have enforced earlier.
Okay, right. Heard Miss Mrs. N. Saikia,
Saikia.
learned counsel for the applicant, writ petitioner, who submits that. Wait, just a minute.
The next up.
Suggested,
Next.
honorable court suggested, then you cannot put in your,
Yes, my lord, you record, my lord, it should not be, but my lord, during hearing, my lord, the court has, my lord, opined that if I challenge, it will be better. Because I have enforced that particular notification, but I have not challenged that. Because that is the only check only, payment.
who
by
are
check.
you? Who are you?
Lordship N. Kalita on behalf of A. Kalita, Industries and Commerce
Standing
Department.
council, industries.
Government of Assam.
Yes,
Yes, Lord.
Where is the central government? Let the central government comment. I want their thing.
today, my
Right,
lord, today, too.
some other day, some other.
Let it be, my lord, after vacation then.
Okay, right.
Because I'm not-
As no one appears for the Union of India, list the matter after the vacation.
All right.
All right.
Give me this in the.